Page which mentioning page number 1, item 1 to 11. Page number 2, item 1 to 26. Page number 3, item 27 to 39. Page number 4, item 40 to 53.
Item number 32, Lords, is.
Item 40.
Item 32 is an infectious, Lords.
What is item number?
32.
32.
Infectious, Lords, is may dismiss.
Yes, sir. Item 40.
Oblige.
40. Yes, sir. Outside. Wait, sir. Yes, madam. Item number 40. Yes. Vikram Chandra. Outside. Shikran. Then wait.
Page number 5, item 54 to 65. Page number 6, item 66 to 79. Page number 7, item 80 to 91.
80. Yes. Orthopedic 6 and post after 4 weeks.
Page number 8, item 92 to 107.
After? Outside. Gurupasad or post after 6 and post after 3 weeks. 93. No, madam. And different matters. Collected matters. Whether who? Yes, sir. Yes, is all of this. One more. I think Indimas is there in this matter. Then I will action in your wait for it. Action in the matters. In time reaches.
Page number 9, item 108 to 113.
Yes. Will reach, sir. Where is 230? You have to wait. No 230 in your court, my court. Yes, sir. I will inform. Okay, item 108. Post after 2 weeks. Respondents. Yes, sir. Mechanics. Yes, madam. One man. No machine, sir. Depend on wait, sir. No machine for the family matter.
Subject of lodged permission. Appellant is not in contact with me last several years. I'll issue a registered notice, then I'll come out.
But when it reaches matter. Wait, sir. Yes, madam. What? Post after 2 weeks. 2 weeks, post after 2 weeks. Guidance notice.
For the extension of pension models, my lordship.
When was it expired, madam?
Yesterday.
Post after 1 week.
CRP 2020, your lordship, against the infant petition,
After 2 weeks. Contempt, sir.
Contempt is in the direction of the court, which is not compared with the contempt of the court.
Then post after 2 weeks.
My lord, my 97 is directly listed today.
We list, sir. We list, sir. We list. Wherever it list is, sir. We list. Yes.
My lord, let kindly recall me that is before the petition I mentioned for review.
I don't post the order. We don't know, sir. Order in section. We don't know. Wait for the section, sir.
I am again seeking from the section is not posted as my application is not applied by under petition. The order copy was discussed 1 week ago and I complained everything numbered also. Either this side or that side you watch.
Post after 1 week.
We have your margin.
Sir, already
He was banned.
you are granted by?
I mean,
Okay, post after 1 week.
yeah.
Wait, sir. I'm coming from here. This side. You have to come that side only. This over, this side over. Yes, sir.
We are not saying.
1 minute, sir, he is there on the line. I'm here only up to 4:30. No urgency. Yes, sir.
448 of 2023. I think we filed on month of February, March, and how much of the service to my service?
Over 2 weeks. Sir, 2 weeks. Over 2 weeks. Sorry, 2 weeks. 2 weeks, sir. 2 weeks, madam. Adding up, sir. Old madam, 2 weeks. No, you're not. Failed to get into madam in this stage. Yes, sir. Yes, sir.
For the landlord, I submitted for the trial court, waiting for 9 years.
CCCA?
CCCA.
After 2 weeks. Yes, sir. Yeah, after 2 weeks. Yes, sir. 1 minute, sir, is very urgent. Yes, sir.
CMA 464 of 2021 first applied, first to obtained stay granted to 2009 years. Because of the section 5 petition is pending, it was never after 12 years of the petition filed. So it is actually this matter is pertaining to the 2005 matter. This is Nalgonda district, so the petitioners are suffering from.
Sir, CMA for the year of 2021.
21.
Just on 2 weeks. Just on 2 weeks.
Lord is 1963 of 2022. It was granted last year. There was an interim injunction to that. Lower court is trying to go for the trial. This was a summary suit. It was supposed to be disposed of, but however, the trial court has granted leave to defend. The Navin has granted injunction in favor. Set aside that IA. However, it is pending for the final hearing.
Over 2 weeks. Finally, in 2 weeks.
Petitioner. That's why they are not allowing us to.
Post up day tomorrow. Day after tomorrow. Yes, madam. No, ma'am, saying my wait, madam. Call the list, madam.
The list item number 1 T Srinivas.
Okay. I was ordered. I have to. No suspendence, post of 8 weeks. I have 3. Stay. But 6 weeks. Then get super 8 weeks.
Item number 2. Yeah.
Wife appeal filed. Parents and the brother of the deceased filed the accepted the order. The wife is shown as a respondent. The granted summons to the parents as well as the brother of the deceased.
Mother is eligible for the.
Mother is saying mother is not entitled.
We are already obtained 10 lakhs per reason 7. You got 10 lakhs. Granted by the. Out of 16 lakhs, 10 lakhs for you.
Yes, the 70% is to the wife and 30% is to the mother in the fusion bench judgment of the Bhopal judgment. In this case, Supreme Court already gave
This matter also 10 lakhs for the.
6 plus 2, 6 plus 1.
No, total, what is the amount? Total, what is the amount?
20 lakh 52,000.
I think already.
3 lakhs to the parents each.
16 lakhs we are already granted for 16 lakhs to you.
Yes, please.
That amount is not 70% out of
Not 70%.
after 23 lakhs.
Yes.
Take notice, sir. No stay.
Father and brother.
Yes, sir. No stay. Nothing will happen.
Brother is not entitled. Class 1, he is not class 1 legal.
But see, mother will get the more compensation, sir.
Not of
Sir, yes, sir. Mother will get both. I have seen. Mother will get more compensation, sir.
Mother is not entitled.
Mother will get. Mother will get.
Father and brother is not
Yes, yes, sir. And only I stay. They got to the withdrawal of the mother, father and brother, not by the.
Yes.
You mentioned all the respondent 1, 2, 3. You mentioned in the state petition. I have an order. to take code performance of service. I think that very case can explain the question. Automatically.
Item number 3. M. Ajay Kumar.
Sir, for payment of the calculation.
Yes, sir. What is this?
190 days delay in filing the appeal.
Who is the respondent here? Respondent number 3 here.
Number 3 is the
Respondent number 2. Again, mentioning respondent number 2 in the appeal is ICC Lambert Insurance Company. But very busy with very appeal. Respondent number
3.
who is respondent number 3?
Response number 3 is the brother of the
This is it. No. Respondent petitioner appellant is
wife.
of the receipt. Both are combinedly filed the appeal, sir.
Sister.
Sister, both are
Sister
sister.
and brother filed the case on the eve of death of the mother. And the brother was granted compensation, sister was denied by the lower court. And the law that he is already married, he is not entitled to any compensation. Brother is also married. Both filed the application.
So you don't want to brother also.
This I have been given 50%, then it will be.
Only 5 lakhs. Well, different like I strongly 50% only. Not with the entire amount. I have
Item number 4. M. Ajay Kumar.
Payment appeal. IA1 is the dispersing application, IA2 is the area condition.
I have an order. I have to process parents. Post of entries. Post for the appellant. Take out for proper service.
Item number 5. M. Ajay.
The payment appeal, only IA1 dispersing.
I have an order. Main case admit notice. Post of entries. Post for the applicable take out for proper service.
Item number 6. If Srinivasa.
How can you file, sir? Mentioning as a TSHC and is filing a another TSHC.
Yes, sir.
It is cost item of the burden. Representing only HSRTC, but what is the cost item? Can you mention?
Yes, sir.
The cost is also same, the lower cost also cost is TSRTC. You have to mention here. Instead of mentioning an TSRTC filed HSRTC official filed the affidavit. Verify with inform. I put her 1 week. I have seen affidavit also. TSRTC is basing on TSRTC representing as a HSRTC officer. You put it on the law officer in HSRTC Vijayawada, but cost is TSRTC. Also, up for 1 week, sir. Verify with. Then you file mentioning here, sir, in the cost item. Matter pertaining to the APS and last TSRTC. You have to mention in the cost item. You are mentioning how can I've seen. There was some like 1 week.
Item number 7. Dharna Statism.
Yes, madam. Yes, I have one ordered. I have to say.
Item number 83, security.
Payments of yes, they are full. Yes, by example. I have an order. I don't know the respondents. Most of entries. Most of the appellant. Take out person. Most control service. Sir, from to court it will not be reaching. Again, you have to come asking for 10 minutes, number of days. Years together waiting for the admission of the case. So only for insurance company are not granting for the person notice. Only private office only I have granted to. Which is the respondents.
Item number 9, please signal yes, Narayana.
Yes, sir. The file cable petition, sir. Climates. No, excessive. Yes, sir. Yes. I have an order. I have to.
Item number 10, please name us.
India of 73.
I have an order. I have to. Respondents. Post after 8 weeks. I have 3. Say, for the 6 weeks.
Item number 11, please name.
I have an order. I have to. Respondent. Post after 8 weeks. I have 3. Say, for the 6 weeks.
Item number 12, others 7.
I have an order. In case it gets notice, post of 8 weeks. Most of the appellant. Order take out from the service.
Item number
Same
13.
as same.
Item number 14, KBK Prasad.
Items to 14. The payment has been already RTC file has been 794 by 50.
Okay. I have an order. I have to. With the required order for this download. A3. Delay 35 days. Notice has to go. Notice to respond. Post after 8 weeks. Post is for the run. MSc member. So, what right?
Item number 15, yes, Suresh Reddy.
Ever ordered. I have to respondents. Most of the blood. Will take out official service studies. Post of it.
Item number 16. Okay, Sudhar Karao Kulkarni.
Yes, sir. Yes, sir. Okay, I will order, sir. What about the IFC? We have 318 days delay. Not just to go, sir. Also, property. I have an order. I have to.
Item number 17. M. Srinivas Reddy.
Yes, sir. Super party. Notice, take notice, sir. Resolution. I have one. Okay, I have one. One. Main case. Resolution. Post after 6 weeks. Hospital the appellant. How to take court for service.
Item number 18. D. Venkataraman Sarma. G. Venkataraman.
My lord, in this matter, I'm appearing for the respondent number 5, my lord. I filed my caveat.
That's fine. What? Yes. No matter. Papers are to the other side or not. If it is there, then serve first papers to the other side. Huh? Yes, sir.
I'm appearing only for respondent number 5, my lord. Papers have not been served.
Okay, don't want papers. Okay.
No, I want papers, sir.
Okay, take a note the other response, madam. I'll post after 6 weeks. Huh? Accept respondent number 5, sir.
Yes, my lord. 5.
Main case. Provision. Post for 6 weeks. Post for the appellate. How to take out personal response. 1 to 4 and 6 to 16. How many members, madam? Respondents.
6 to 16, my lord.
9 to 16 are necessary parties. Okay. 6 to 8. See, you can take notes for the rest. Actually, you filed for respondent number 8, sir, not the 5.
No, my lord. I am for Vishwakarma Sangam, my lord. Respondent number 5.
Vishwakarma Sangam.
Yes, madam.
Where is your payment?
I've also filed my wakalat yesterday, my lord.
Okay, respondent number 5.
Yes.
Vishwakarma Sangam, film, Patamanan Kajipet. Okay, respondent number 5.
Yes.
It was post after 6 weeks. Yes, sir.
Publish.
Item number 19. Maybe Ramna Reddy.
Yes, sir.
Not referred a lot. Depended in this total. For mandatory injunction. That was dismissed by the trial court. The appellate court allowed the clear suit. This is the second is filed.
For delay, 100 days delay, sir. Take on respondent. I have a respondent.
Item number 20. It is Palkutti, A. Anand Singh Reddy.
Next one for papers recorded. After 1 week. First person.
And then substantial questions are there.
Oh, we'll see that. First person. You would have the current. Each time. Post after 1 week, meantime. After that. Related to further papers. What else? Yes, sir. Play.
Item number 21. Rudresh Deshpande.
Yes, Rudesh.
Answer HMOC. On senior civil because of it, filed by the respondent.
You all find any criminal case, MC 498 Chennai.
Deciding it.
Mancherial to your native place? Chennur? Oh, what is the distance? Chennur to Mancherial? Okay, 2023 only. June month, they filed HMOP. When you filed the full case, August. After receiving, filing out the OP, you filed 498. Permission, formalities, possible petition, how to take court for service. Available, the social rules, HMOP number 32 on the file of serious village, Gopalpalli. Yes, sir. That is take. Take on it,
Item number 22 is CV Ratna.
yes, madam.
May I please your lordships. The issue under this transfer CMP arises under ME Act Millard. The petitioner's husband died in a motor accident. Then Millard, parents-in-law and Millard, brother of the Millard deceased, filed OP at Secunderabad court back without implementing the Millard petitioner before lordships. Millard, she doesn't know about the Millard pendency of this OP and Millard, she filed another OP at Warangal where she is residing. When the Millard, the insurance company filed a counter, that Millard already there is one OP at Secunderabad, then only she came to know about this Millard
Yes,
OP.
madam. Okay.
There is no dispute with regard to marriage, as my lord, your lordship may see at page number 16. Mother-in-law herself filed a suit for declaration. Now, my
16.
lord, I am seeking transfer of this Millard OP filed by me. As my lord, it is at latter point of time to the Millard Secunderabad court. Where
You
the
are
Millard
also want
parents.
for the, your case has to transfer from the Warangal
Yes,
to Hyderabad.
Yes, my lord.
Okay. You go password is madam.
Millard, meanwhile, Millard, there may be stay, Millard,
I will
already.
grant statement. I will grant stay.
Yes, Millard, PW1 already examined.
Possible petition, possible take court, possible to service, post after.
Your lordship may fix a date, Millard, so that.
6 weeks, madam. 1912, 6 weeks.
What's up, please?
11. This will start processing. MBOP number 16/2020 on the file of motor actions crimes tribunal come 27 additional chief judge series reported Secunderabad. The country will only case with easy. Yes, madam.
What's up, please?
Item number 23. K. Mohan.
Yes, corrected.
Since this is a wife lordship seeking transfer from Hyderabad to Rangana district. Parent lordship 5 cases are there.
2019 matter. What is the stage of the cases now?
So coming for evidence lordship, their PO is also given.
Huh?
Coming for evidence.
So not mentioned here. 2019 matter. Take out notice. That's perfect. Nothing will happen. Main time. Only this will go to Rangana district. Alvi Nagar. Yes, sir.
Father is going to Andhra.
Nothing will happen. Hyderabad. Where is your residence, sir? Where is your residence? Tell me.
Please cover that lordship.
Master Karman Ghat. Same distance for LB Nagar to CTC court.
Lordship 1 year.
No, sir. Take notice, respondent.
Children is school going, children is there lordship.
Nothing will happen. Take out notice. Makes no difference. For Karman Ghat to LB Nagar and come on to civil court, same distance.
Apart from that, many cases are pending.
We'll see after, take a notice to respondent.
Limited. You will also say this limited streaming.
For your satisfaction.
There is another. You might be. Other is also
There is no proceedings. Well, you also leave. Huh?
She may come.
2019 matters, sir.
Both are connected.
Both are 2019 matters. 2020, after 4 years of filing the transfer petition.
Delay, there is a COVID also. Yes, nursing. You can have a personal notice nursing.
What are the other cases in Tangareddy court?
DBC partition food from the nursing. I have stated in Telanganahigh court, 18 nursing. Apart from this nursing, the petitioner father is suffering with eye problem.
Partition filed by
Both the responding family nursing petition is included. Assessment family nursing, in order to deny the share to the petitioner, they are filing partition. 5 cases are pending nursing. It's very difficult to attend that there and here. In both cases are clubbed and treated as one case nursing. This case may be for
so filed criminal case in 2020, maintenance case in 2022, Golden appeal filed in 2022. So you want transfer the 2019 matters to the both matters of 2019.
Both matters filed by the responding to only nursing.
Yes, sir. Here, next case.
With regard to 19 nursing, 19 column nursing, I have stated. Krishna mother went on operation nursing and also father is now.
That accounts are Kalmangarh to Rangared, Kalvinagar and Kalmangarh to civil court. What is the difficult, sir?
No, father is accompanied to the petitioners nursing. There is a regard to the petitioners already.
Bhartan Bhatter Hyderabad. Where the question coming by father attending the courts.
Recently, the attack to petitioners nursing. And I have a copy of it. Responding to the attack during the station tension.
Show me.
Nursing to.
Yes. Both are filed Karno piece. You are also filed Karno piece. He also filed Karno piece.
I filed it to the district court.
FIR page number 40 page number 2019, sir. That is FIR.
Recently, another FIR was issued. Page number nursing. It's 7 to page number 5 is number 7 nursing. Last month nursing.
Second case or first case?
This is second case nursing. We are attacked on the recently they attacked
64, 65 page number 64. The 506. Intent to 2022. Complaint. Asking. Asking Sanjay Singh. This is private complaint, I think. Private complaint, not police complaint.
Police complaint also district. Recently, we are attending the maturity function of the first quarter nursing. We are attacked. Yeah.
Okay. First after 4 weeks, cause for the petitioner control take court of service. I1. TSHC. Comes in the FCOP number 710 up to 2019 on the file of Partition Family Court. This is report. Rakan Kalpakaru, Hyderabad. First case. Next case number. The both are connected. Next case number. WOP number 60/2019. First case. Family Court. This is report. Kalpakaru, Hyderabad. NBA, both parties NBA. 4 weeks.
Item number 25, yes, Surendra Reddy.
Yes. Maintenance already I attended me.
Yes, ma'am.
Road solution, post office. 6 weeks. Post office division. Take out service. I1. This is self person section of number 600 to the file. Senior related in the chat.
Item number 26. Now the syllabus now.
Pass out.
Item number 27. B. Shesh Kumar B. Durganageshwara.
When coming to the letter is yeah.
Item number 28. Chicken Narasimhara. B. Prabhakar Reddy.
Yes, sir.
The response to that. The Krishna to the election, project the artist.
Right off. Give the weight. It is that.
Others to the election, the police say granted in favor of the respondents to elections. Page number 6 to elections.
Yes.
Act of the case to elections. My wife is the first petitioner's wife is the agreement holder of the defendant's elections. Where they are the landlords, I am admitting that. Where my wife filed a suit and for specific permanence, see the same was dismissed. She was preferred appeal. Appeal pending, without made her as a party, now made me the husband party and filed an injunction suit for election. Me and my servant. The petitioner before the elections, myself and my servant. They was not properly made the proper party who is the my wife, who filed the principal permanent suit and the same was dismissed. We have.
Sir, your wife is not entered the lands. Only you are entered.
They have given,
Where is the question of
they have given position to election, they have to use the amounts. That is the judgment is there, appeal also there, you election. Only because I did not, my wife did not enter into the witness box. But technical plan, it was dismissed to the election. Anyhow, your election, the police, they have interim injunction granted. Agreement that we have preferred CMA is pending. Now police protection are granted your elections, contrary to the judgments of the Assembly Court, including the decision. Earlier, I have given one judgment to elections. There is a election.
One of Nagaman judgment was saying. Subsequent number of judgments are there.
Yes. Nagmani is a BJP. Now I have given the election.
The Nagaman is there. It's
The
US.
division with recent judgment also in election by his election. Writ appeal number 187 of 23. That also I.
That is by only repeat, not by the.
It is also there in the election. They can file for contempt or otherwise.
By the this is Putungwaya, he was by the
Yes.
but the only question I by the we have to approach this, we have to civil procedure. That is a finding.
No, civil, not civil procedure.
This is last para. This is
Yes,
last
yes,
para.
election may. Accordingly, granting liberty to the applicant to avoid the remedy under Article 31 would do a, that is contempt they can file, not police protection. That is after your election. Last paragraph, page number 7.
Please have a copy.
Paragraph 17. Paragraph 17, you will watch the election. They are ready for file 2A.
Yes.
Not police. Accordingly, granting liberty to the applicant to avoid this.
That's 15, sir.
Yes, you are. From the above, it is effect that if there is any disobedience of order injunction made under Rule 1, Rule 2, under the CPC or breach of any other terms on which the injunction was granted on the order made, a court granting injunction or any court to which the suit of proceedings is transferred may order the property of the person guilty of such disobedience of breach to be attached and may also order such person to be detained in civil prison. That's a 2A. For a term not exceeding 3 months unless they maintain the court directly release. Therefore, Rule 2A of 39 provides
and adequate and efficient remedy to a person who is aggrieved by disobedience or breach of injunction or continuing is one.
Next pair. What they are filed?
That being so,
WP.
we are of the view that the petitions filed under prudence in India seeking police aid to enforce the implement and order of injunction and to restrain person from interference with the order of injunction should not be arbitrarily entertained unless an element injury to the public or infraction of statutes is made out. Otherwise, it would amount to entering into arena of private disputes.
This contest only they pass with the orders. Yes, sir.
It is also clearly said that you will have to, I think, 2 years only that they are in the normally judgment also you have to clear it, you have to
Yes,
paragraph 30 you will
yes, paragraph 30.
last 5 lines you will have to go. 30. As that the husband of the complainant and others violated order of injunction, it is certainly not a case for ordering police protection, but it is a case wherein defendants
Sir, here
can.
first read is Corona, para 24, not well, last para. Guidelines are there. 1 to 4.
24 also there.
Para 24.
Yes, yes, ma'am.
Guidelines. Read.
Later, this court has noticed that the number of suits for injunctions in all courts is one.
You know that para, the guidelines is there, sir. When the allegations are 1, 2, 3, 4 is there.
Party obtained an order of injunction that the said order has been violated and application seeking police protection would not lie. The aggrieved party has to necessarily file execution petition under 2132 or an application under the order 39 rule 2 of CPC seeking arraignment and the arrest of the violation of contempt of the court. When a petition is filed seeking police protection, whether or not an excess of the powers under section 94E or section 150 CPC, the facts alleged are pleaded in order for police protection cannot be passed in a routine manner. If an application is filed by the person obtaining an intermination, alleging that there is a threat of breach, disobedience or violation of the order of injunction, subject to proof of the court has power to order police protection, imposing necessary conditions not to interfere with the life and liberty and rights of the opposite party.
Power is there, court has power to order protection.
Life and liberty is not for property, life and liberty. But regarding when you are like they are entering,
High court has power to grant police protection. That is the diligence.
for liberty, not for property. Property is
Next
clearly
guidelines is there. Next guidelines is
the
there.
standard of proof required in the case that of disobedience of the injunction or alleged breach, disobedience or violation of the injunction should be very high and it should be between the standard of beyond reasonable doubt and standard of balance and probability.
Yes.
Be it noted as held by Supreme Court in Chotura versus so and Anilatna so and so. In all cases, contempt of the plea should be proved applying the very high standard of proof and not mere affidavits or self-serving statements of the party seeking the intervention of the court. It is also your only, it is not right your election.
I want to find them, should be finding of the trial court.
Yes. Page number 6, start your elections.
Yes.
Read page number 9, there are 5 numbers. It is admitted fact that IG number 159 of 2000, the Honorable Court granted temporary injunction restraining the rest of 1 and 2. Their main agents are other from interfering with the peaceful question and enjoyment of our business or the petition scheduled property till disposal of the main suit. The suit is pending and it is coming for trial. In this circumstance, the plaintiff filed a petition for extended cooperation of the police to implement the orders passed in so and so. If the respondents are continuously interfering with the peaceful question of the plaintiff over the suit scheduled property, there is no meaning of passing of the temporary injunction in favor of the plaintiff. If the protection is not granted to the prisoners, the very purpose of granting temporary injunction will be defeated. As the court, after going thorough entire record, felt that the police protection is granted to implement the orders of 159. No harm caused to the respondent. Where is the legal action? And police will extend their cooperation to the petitioners only for implementation of the orders of the court in IG number 1. There is no change to grab the land of respondents by using force of the police. Now what they are doing, your action.
Yes, yes, continue.
There is no chance to grabbing land with the police protection. Hence, after going through entire record, it is concluded that there is necessary to grant police protection to the for implementation of the order.
Their affidavit. What is the affidavit filed by them?
Affidavit page number 12 your election. There are 4 answers. The Honorable Court issued the temporary injunction order so and so, and subsequently the Honorable Court heard both sides and he said temporary injunction orders were made absolute in IA numbers only. Till the final disclosure, the injunction orders were served to the respondent and both them are well aware.
That's right, sir. Verifying color.
Submit that as this matter should like this. We have raised the big crop in the Sujari property during the agricultural year 2018, 17-18. Again, first time independent, although his school is responsible to the scheduled property about so on 11 AM and but for the myself and my brother have resisted the illegal acts of the fundamental and his men, and they have abused us and threatened us. As such, I have filed the complaint to PS Local and the police officer so and so crime. In the same manner, the respondents defendant have disobeyed the injunction orders 1829 and also 2561, and we have filed the complaint which is PS Local, the police worker filed file number 155 and 19 of 2000. There are other criminal cases filed by me in three cases to elect. Only they are here supporting the police to elect by using influence. They are creating several cases on me elect. They are purely civil in nature. As the respondents defendant never obeyed the injunction orders issued by the harmful court due to their illegal activity, even though there are several cases pending against them. Even after passing the injunction orders made absolute and so and so by the Honorable Court, the respondents defendant again tried to plug the cartograph and the visible planning in the social property raised by us on 13/2/2022. But we have resisted the illegal acts of the respondent defendant and sent them out with much difficulty with the assistance of the adjacent landowners.
Submission below.
Is it completed?
Yes, well,
Huh?
can you read my counter?
Yes, I want. Just I'm going to control this. What is the answer for the criminal cases? I want to see your counter. Yes.
There are number 4 on assembly. Submitted that email at the time of filing the petition.
Sir, there is no answer for the registration of crime. Your counter.
They are mere violations.
You are not denied a registration of crime, and you are not entitled in the violation of the orders of this.
State by hook or crook by taking advantage of orders of the Honorable Court that the person who is intentionally misleading the orders of the Honorable Court cannot be protected by way of giving police.
Very vague reply, sir. Very vague counter. Huh? So specifically mentioned dates and
That will be taken by the police due course.
yes, sir.
Where what they are saying to the charge sheet.
Specifically mentioned dates and the criminal case pending against you. You are not given any answer. You are not given any answer to that your counter. That's why the court will have granted a first production to the respondents. They are not setting the village. They are setting out other villages.
Trying to implement the illegal actions, which is the not absolute action or CMA is pending action.
Absolute, sir. After filing counters only they filed made absolute. Then only you filed the CMA. There is no stay. There is no stay. In CMA there is no stay in favor of you. That means
In
become final.
general action, they are not giving any.
no gender. Yes, sir.
Submission below.
Yes. Yes, I understand.
Page number 80 showing that very clear statement below. Page number 80 below.
18.
80 below. The statement of the Honorable Court below showing that very clear below.
Where is 80, sir?
Is 80 documents. 80.
Of your counter.
Yes, below. Counter below. From all these documents, it reveals that exhibit A1 to A4 are fabricated and created for the purpose of this case, and the plaintiff should not take any lenience of defendant. It is showing that very clear below statement. Each and every document created and fabricated by the petitioner's wife, my lord. His first petitioner is the husband. Second petitioner is
I am
the
reading
following
page number
page number 80 below.
80, sir. Wrongly my
Counter below. Main counter below. Date of counter.
page number 40. Last one only marked right there.
Yes, ma'am. And all these documents, it tells that exhibit A1 to A4 are fabricated and created for the purpose of this case, Miller. Petitioner wife, first petitioner is the third party Miller. Second petitioner also in this civil division petition Miller is the friend of the first petitioner. Miller. Second or if any both are third parties Miller. Petitioner's first petitioner's wife filed the petition for social performance and the same was dismissed. Based on the reason Miller.
the entire documents or exhibit A1 to A4 fabricated and created, my lord. Each and every, my lord, one more submission, my lord. The petitioner not having any single piece of document is there is no having right and title, my lord. There is single piece of document that they never produced at any point of time before lawyer for this honorable court, my lord. Never find any single piece of document, my lord. We find, my lord, page number 138, sorry, my lord, 142, 143, 144, 145, my lord, showing that very clear, my lord. Records of rights, 1B, my lord. These petitions, the respondents are the owners of the property. From the date, my lord, having possession, presently having having possession, my lord. Today he is having possession, my lord. One more sufficient, my lord. The petition supported this honorable court, my lord, granted the Indian Markets, my lord, on 6th January 2023, my lord. Considering the circumstances explaining upward filed in support of the petition and circumstances made by the land council for the business, also order dated 7/9/2022 in IA number 108/22, 78 voice number 78 of 70 Miller, Langan Stone Russian business mother is the sustainability date 19/1/2023 Miller. After next day Miller, they approached petitions approached the land and grabbed the property, damaged the entire property, Miller. Doors, broke the stones, damaged the complete prop, Miller. It's showing that very clear, Miller. Next day.
Where is 19/2023 order?
Initial order. This is the initial order, 6th January 2023, Miller. After that, Miller. And the next after that, he lodged the respondents lodged the police complaint before the concerned police Miller. The police lodged the FIR. We find that very clear. 21, they lodged the police complaint. They made the FIR still pending Miller. And again, and again Miller, the honorable court granted 19 January 2022, the same was mentioned, Miller. Also, showing the very clear, Miller, the land council for the respondents has submitted that they have already filed counter and that having obtained Indian market from the store, the petitions have destroyed the crop of the respondent and to that effect, they lodged a police complaint before the police. He further submitted that they have obtained photographs of the above acts and sought for vacation for the other Miller. Submitted the FIR Miller and with pen drive Miller, showing that very clear with photographs Miller. The photographs are showing that very clear Miller. Already filed Miller. I enclosed the pen drive and the photos Miller. Come on, wicket petition Miller. I filed wicket petition Miller. Wicket petition date with pen drive with photograph Miller. Along with the FIR Miller. Pendrive photos with pendrive file on 9 March 2023 Miller.
Yes, sir.
Showing that very clear Miller. Photographs with pendrive. Photographs showing that very clear. Pitfalls are totally damaged Miller. 2 lakhs rupees lost by in this incident. And again Miller, one more submission Miller. Recently, one more FIR made after that Miller. And again, second time over Miller. Second time also damaged the property. And again under section second time 19/8/2023 Miller. In under section 447, 427, 34, entire property is damaged. So in the already the same FIR also submitted before this honorable court Miller. Recently, just to 10 days back, 31st to 23 Miller, and all FIRs Miller, which is showing that very clear. Each and everything is showing that very clear Miller. There are 9 FIRs, Miller. Granting this honorable court Indian Martin Miller, 2 FIRs made by the police. One is August, one is January 21st January Miller. Several FIRs.
Sir, case law filed by you. Yes, sir.
There are
CRP, orders passed by who committed this order? CRP number 4687/2013. This is MS Amsandra's order. You have submitted. You have submitted judgment. This is MS Amsandra's.
submitted.
4687.
There are 9 FIRs still pending Miller.
Yes, sir. I understand the case. Yes, sir.
Point of time, passing the petition. Both petitions are for senior citizens Miller.
Yes, sir.
Age about 74 years Miller. Petitions 1 and 2 both are the public litigants Miller. There are the third parties. They not having any single piece of property Miller. They never produced any single piece of paper Miller. Party
Government, sir. Government is arguing. Yes,
She
sir.
never approached before the lower court Miller. Each and every point of time. She never approached. That's what is dismissed. The time of giving examination also she is not present Miller. She never given any examination. Examination, deposition.
He is not party, the CRP also.
Yes, Miller. Miller. This CRP, both petitioners, third parties. At the same time, both are litigants. The habitual offenders Miller.
Yes, sir. I understand the case. What is the reply, sir?
And you see page number party of the CRP election. When the Tehsildar reports chairman, saying that I am not filing anything of papers. Instead, I am not saying that these are not bonus. They are capitally bonus. Specific funds will file by my file. Now, that is the page number party. The Tehsildar reports file 11/2020 election. The report of the Kirdawar, one that submitted report stating that Srimati Chanda Sharma, Srinivasrao is cultivating the summation of said land presently. The Pani extra for the year of 2020 and report of the Kirdawar, one is enclosed for taking further action in the matter. Now, admittedly, position column is not there. By taking undue advantage, you are likely to influencing the
Wait, sir. What is the letter?
5/11/2020 election. That is that report to election to the essay.
Not a report, sir. Page number 40, 39 RTA Act. 40. 2020, sir. That is 2020.
5/11/2020. What I'm saying. 5/11/2020.
Yes.
Is the when the FIRs report registered by the respondents civil action, the police requested the Tehsildar what is the position. Then Tehsildar given this letter to the police for filing the further investigation.
Sir, I will mention your counter in this matter, this document.
I have filed against CRP.
Not CRP, sir. In the counter in IA, the time court. What way they Tehsildar and giving report to the SHO. How can take into account pending civil case? Judgment is there. You cannot take into account the Tehsildar report
It is
pending
not
civil
title.
case.
I am not saying
Yes,
I am not title. I am having position that is
Question also. But take not taken account of the Tehsildar report and the judgment of this court.
Then they are admittedly owners. I am not denying
Yes,
that.
sir. I will pass orders. I will pass orders. Not unless I have seen orders, not necessarily. I will pass orders. Here goes it. Post orders after 3 weeks. I will pass orders.
Yeah, please not maintain the contacts with the label to distress me.
Yes, sir. That is your prayer. I understand. Request. Request. First thing.
Item number 29, yes, Chandrasekhar.
Yes, sir. What is this? CNA? There is no I. Okay. How many days delay, sir?
1,500 days.
Yes, sir. 254. We don't want some thousands, sir. Only just 2544. Huh? Sound is different. 2544 and 2500. What is the actual date of? What is the limitation for filing appeal? 1 year. Okay, constable. That's part 6 and orders post after 4 weeks.
number 30, Vivek Jain K. Venumadhav.
Actually,
Notices were ordered earlier. I asked for interim suspension. Notice was ordered. Now, they refused notice, then notice was ordered to the lower court council. Now they have entered appearance. My grievance is this thing. They asked for injunction for 14,700 odd square yards on the.
okay, I hear you. Last occasion. Yes.
You want to minutes of submission. Reading what is there already on record in the trial court. Now, correctness of the trial court.
Yes, I agree. They want to time, they ask for the filing count. Otherwise, there is no count necessary for the, if you are after time, petition after time, does not say that no count necessary for this matter, we hear the matter.
This is the correctness of the order is being listed. Till such time interim suspension may be granted because they themselves admit that there is no registered agreement and the document is not exhibited. Still, injunction is granted for 14,700 square yards.
I think already heard you.
Yes,
This is
sir.
this
Right.
is,
After the judgment, so they ought to have had a super specific performance. If want to argue, I need to let it be next Tuesday. They can find counsel and argue the main. Otherwise,
I give 2 weeks time, sir. Just now we entered the appearance. First first part 6 time for 2 weeks.
conditionally go for the rejection.
Coming first 2 weeks.
Item number 31, Dilki Bangladesh
Yes,
State
sir.
Sabla Mahindra Reddy.
That entered appearance.
I am appealing to respond on 192, my lord. Connector matter is 5546 of 2015.
Representation 293.
2000.
Delay means no objection, my lord. Delay means come on.
One minute, sir. What do you want? Sir, you are not the sympathy? Condemn delay petitions.
No objection, my lord.
Delay petition. Yes.
No objection. No objection.
Yes, sir.
Another matter filed with my friend. That is EMA 546 of 15. Not because arising out of the same policy. Now this has to be clubbed together.
Yes. I have one request for petitioner respondent. Allowed by the petitioner by the respondent, the delay of 24 days condoned for the resubmission of the CMA and delay of I2 get for petitioner respondent. Allowed by the respondent. Delay of petitioner condoned. Main case admit. Post LR admit. Post of final hearing LR.
546 of 15.
CMA number 540 of 2015.
546.
546. 546 of 2015.
15.
Then
Then
next week,
post after 8 weeks.
your lordship, next week, my lord, it is coming for filing in that matter.
After 4 weeks, sir.
Lordship, 1 week or 2 weeks, my lord, it can be completed.
4 weeks. After 4 weeks.
Item 32, item number 33K, Honorable Shyam Sundar B. Geeta.
Yes, sir. What is this case? What is the council? What is the case? What is the case? 2021 CRP. Next. Shall mention status quo also filed. What is the present stage? Assume. Yes, you are sections. No, after 2000, first April 2021, first time today, after 2.5 years. Yes. Let us both sides post after 2 weeks. Winter condition section.
Item number 34, T. Venkat Transform.
argument here. What could not be done? Move on the petition, post after 4 weeks. That question is answered. And then
Item number 35, K. Pawan Kumar. Him on this thing.
yes, let us success. Yes. Post after this is that. And we can record this in this missile purchase.
Item number 36, K. Praveen Kumar.
मतलब dates 2019 to 2021. Other text posted no data also. It's not 2 weeks. It's not today after 2 weeks. Of dates. What is the year? Please expose for the 4 weeks.
Item number 37, Young Sridhar Reddy. Srinivas Taluku.
Yes, for the stage action, for the case.
Required supervision at the start, just passed an against EMF. The instructions of this matter. What is pending? Short date will be prepared.
Yes, ma'am, what is your session?
In favor of business control.
This vision is prepared against the orders passed in again.
Order section
Yeah.
2.
Does not comply with the use the year of demand.
What is the demands for this course?
To suspend the orders passed in again. This suspension.
No, now. Good proceeding, sir. Only regard the orders passed by the. What is the prayer in the?
Suspension of orders passed by for additional discharge in ID number program CMM.
Business sections are clear. Hospital period 6 and 4 for 2 weeks.
Item number 38, Sheikh Madam.
All my talk of February 2021, coming first time. 2021 matter. Section 5 implementation for critical times. Because the petitioner post after 4 weeks.
Item number 13 is Nagesh Reddy. Go to the
Almost, I think, children are almost all infectious.
item number 40, C. Vikram Chandran, TSHC.
What is case, madam? What is CRP? What is IA? Petition in respect of jurisdiction, the unnumbered within suit petition is returned for presentation before the proper court. This court does not entertain jurisdiction to deal with the application filed by the petitioner under the Table of Arbitration Act, challenging the arbitration award, which is based on the arbitral proceedings that were held at Mumbai, as per the decision of Honorable Supreme Court that such discussed so far. Only competent court at Mumbai would have jurisdiction to deal with the subject matter. What about the CRP? That's right. You have no objection. Also, petition 6 and 4 for 2 weeks.
Item number 41, Rakesh Gandhi.
Because it is post after 4 weeks. Next matter,
Item number 42.
42. Cause for the petition, cause for the sponsor. In case of this court, post this matter. The other court will escalate the other party. Petition cause also. Myself is respondent. Alex, I'm quite vocal for respondent. I'm the man. Alal Kalyan filed vocal. Okay. Nanda madam for the petitioner.
Item number 43, K. Amarnath Reddy. Kishan Rao.
Yes, sir.
Yes,
Yes, sir.
ready to argue.
Yes, one other test.
A little long back, copies with me. Can they say that I filed it on 11th month of 2021 elections? Is a copy of copies. It was by given them. How they coming election is for 5 for declaration. Calculation of saving and recovery of position election. There are the sky now there, second week. Now, it's not going to the challenging of the then the document was issued by the subsequent science going to.
Yes, sir. What? Yes, sir. Not only.
That what already previous was exam election. Exams are marked. After also marked. Now they are when the prediction the right matter election. There is no any grounds for the.
Sir, you have filed vacant petition for month of 2021 December. When you filed vacant petition? December 2021. Will not mention any data file letter to the principal posting of case. All of a sudden, listed matter after 26/2/2021, the matter was listed last, granted into matters. Thereafter, after 1.5 years, more than 1.5 years, listed before this court. You are insisting for the vacant petition. No, sir. Also, we have 6 times. After 2 weeks. Wait for 2 weeks, sir. 2 more weeks. We waited for 1.5 years. 1 year, 10 months waited. Wait for 2 more weeks.
Item number 44, K. Mohan.
Yes, sir. But in demands granted by 5/30/21, sir. Coming second time only. We applied in demands, sir. Second time today. Notice of admission is 3 weeks. Performance permitted, sir. Already filed. What's IA? And this orders 826A FCPC. Counterclaim is allowed. As defendant proof 6 to 8 counterclaim allowed. Yes, sir. Without shown matter. Once the stay is there, they will not proceed further. Of the for the only
Feelings are not stated.
but then still found all the proceedings, sir. Okay, you see, once for the petition. Next, getting section 4 or 2 weeks.
Item number 45, yes, Nagendra Mohan.
Okay, for the petition 4 to 4 weeks.
Item number 46, D. Venkatramana.
Then March 2020. Docket. For 4 weeks.
Item number 47, Krishna Kauri, H. Srikanth Gaur.
You have to begin.
Okay.
During the pendency of appeal for restoration of arbitration case, CRP is filed. Part of proceeding. Meanwhile, that is restored and also dismissed.
Equal purchase. Sir.
Item number 48, S. Anand Kumar.
So what about respondents? Not served notice to respondents. Just on 4/2021, none appear. List after 1 week, but not listed till today. No notice was goes to the respondent. What is the? Yes, sir. Whether there any issue?
Yes, ma'am.
What is the liquid on this matter? Sir, 12/10/2020. What is the document? 12/10/2020. 12/10/2020. What is the order, sir? Sir, also request 25 to permitted to send notice to respondent 1 to 32, R1 to R32 through email, fax, and instant message. Date of adjournment is given at the request of counsel for petition. That is the grievance. Whether order, sir. The question only the player is agreed by the orders was dated. Data dated 12/10/2022. That is 12/10/2022. What is the wrong? We are not pursuing this matter since 3 years, almost 3 years. Data date is 12/10. Now we are in 23 November. Document become infectious, sir. No, sir. TRP is not maintainable as docket order without any just issue notice to respond. That is only orders passed. Senior counsel argue this matter, sir. Only read it again. Where the legal point in this matter argue that only the notice to the respondents only. That is date of 12/10/2020. Read once again. What is the legal point of with this code in CRP? There is no legal point, just only reported. There is no notice served or not notice served. That is the only part. Docket order. And post for orders, argue the matter. Here comes the petitioner. Post for orders after 2 weeks.
Item number 49. How many?
What is this matter? So last time I extended in the orders.
Yes.
Yes, we are
The next matter.
4950 and
it's a Kirtana quota.
Yes, sir.
Kirtana quota. Sorry.
and 160 here and
40.
4950 and 160.
Not expired by
Asham mobile.
Yeah.
but already posted sign the ring.
It's very simple point. But after a lapse of 18, almost 13 years, the defendant number 7 had order. Having knowledge about 13 years, the counsel for the D6 is husband of D7. He is contesting D7 made an ex parte, and D6 is contesting and our counsel is D7, husband of D7. Now, after watching 11 years time and keep quiet all these years, now when the D6 is not cooperating to go into the witness box, now D7 filed a certified ex parte order, saying that your lordship may kindly see the petition D6 is unsound mind. She is not in a balanced mind. That's the reason why the D7 will start to be certified ex parte order. Page the petition, page 13 of my material. And in fact, thereafter D6 comes to the before the court below, to say she wanted to change her counsel, and that is also she filed a memo. And
Wait, sir.
I don't know why they are seeking time. If it is necessary, definitely your lordship can grant the time.
Your Lordship may kindly see. Now the affidavit filed by the D7 is not page 13, saying that D7, D6 is not in a balanced mind. The her own statement before the court below, your Lordship may kindly see.
Lordship may look at the docket order dated 22/2/2022.
Yes.
Can I pass on the docket order?
22?
2/2022, we have already filed it. That is passed.
That is page 19 onwards, all the docket orders have been filed. Page 33, Mr.
Only 4-1? Page 33. Docket order
Page
date.
33. Page 33. Memo filed by counsel for the defendant number 6 and 7, stating that the plaintiff admits.
Lordship may look at the feedback.
This is actually the madam. You filed all up to
Yes.
28-1. I think neglect of hearing means you filed 4-1. So filed. This is 22/2/2022.
Memo filed her statement also. But this is tagged along with this period, IA filed, IA 1/2023. That page 6, page 6 of the material paper filed along with IA number 1.
Madam, I have one. After the 23. Intended to change her counsel and she is hale and healthy and requested time.
Yes.
This is fine.
Because she accepted this after the witness box. And the statement of the Miller D7 is totally contrary to the Miller fact. And misrepresentation Miller before the court. IA was allowed. Against that Miller, we filed a CR.
Yes, right. Proper response. Each time. Post after 2 weeks. Yes, 3 matters.
In my matter, interim order needs to be extended, but it is not given until further order. Item number 50, they are only
Same suit, sir.
different suits, 3 different
She
suits,
is one of the same Miller.
but 3 different.
They-
So we make this also until further orders. In terms of the matter.
175, okay. Last case action date, sir.
Extended until then it's done.
Okay.
In my matter, it's extended till.
That comes for the response 6 time. Post after 2 weeks. Given by action date, under orders. Post all this matter, 3 matters, 2 weeks. And the 106 way, in front of the side, wait. Okay, let's see.
Item number 51, B section ready. Take note.
Yes, it is.
Yes, sir. Ready?
On the last occasion, the lodge directed to serve notice to the respondents and then by person.
Respond number 2, 3. How many respondents?
4 respondents. I appear in the part two.
MS Srihar Sharan, advocate and C. Proceed as advocate. Yes, sir. Ready at 1 time. Are you ready?
to the order. IA number 309 of 2018 matter. Police number 41 of 2018 matter. 2021 matter. And stay is filed. IA is for the appointment of advocate commission. To make any vote to include or in my IA, the order. This is no counter is filed by the respondent in my IA. Page number 9 matter. Here filed by me.
Yes.
May I read page number 9 matter. Paragraph 3. That is admit that the respondent in the contract admitted the policy for the disputed is boundary during the weekend, like contention that the contract will be he said admit that I have no commitment to the number 3 claiming the land are trying to impose illegally. But I have that is the only conducting the survey very competent like the other survey and lab survey demarcation between the so there. But I have that when you want now go there so higher by there is no counter. After very go to the order page number 6 and 7. Detail of the entire part. That is for the end of particular nature and doing dependency of the two point with the publication in order to keep the notice. Those respondents are not quite counter by allowing this and with the amount especially of the evidence, they by calling to this and the additional so they reduce the evidence and since it is used for emission because it says public emission my country to even though between the after the problem. Earlier to this matter, I found emission between the same. In that they find a counter not to any to 18. Page number 18, the counter find by the respondents in the injection development. Others have been find for injection, so we never and they have no intention to repair in this and use the outflow. Initially, modified interest to find injection to grant I said circumstances to petitioner to be instructed to market the boundaries of the canning screen. The petitioner will take the mission with the accepted counter with a dispute between the parties like the created same created. The serial uncovers another example to tell Mala to get a dispute between two surviving and two parties. The indication dispute also when comes can be appointed. That matter I pass on this judgment stuff. In the judgment matter, page number 1 matter. 2015, 16 AAD 460 matter.
15 5 is
any go to the page number 4.
para number
Page number 4 matter, para number 30, 14 matter, 15. The number of judgments are required in this case, and rendered judgment pages page number 16 and 17 are relevant. I will refer page 16 and 17. The various cases are discussed earlier. In the present case, from the meeting of the party, it is clear that it is the petitioner who will go in the property, but the petitioner alleges that it is the respondent who has shown the property. Therefore, it is necessary to localize it to the property, and this can be done with the help of the advocate. Instance of the one of that and also given FB and other both airline holding that when the applicant comes note down physical figures, no one disputed about the expiration of the school property. Further lapse of 6 months, the petition came to the description because of the beginning of the party mandate to decide who involves the whose land I will regard to the case now mentioned above, I have the opinion that court law is not correct in body that there is no necessary for assistance of the court commissioners. And if really it is necessary to appoint a court commissioner. So if only when the evidence are not leaves something to be explained further. Therefore, this case matter, I say by opinion, the first notification of the dismiss legal claim provided matter. Court in matter is for identification of property. You have to be decided also for injection. This case I excited. Explain matter. Page number 1 to page number 6. 2043 is not fine. Okay, group data, page number 80. Para number 11.
Yes, sir.
There is a case where there is a report with regard to the identification of subject matter. Though there is a report of the survey, the report is disputed by the commissioner, and the assert that the survey is to be conducted in the presence of the commission appointed when the report below. This report to 12 minutes, come from the page on number 13. In the road under the room line, part in any school in which you need to open case is necessary of power. In which case, in any matter in the school, it is to take issue commission. No issue commission in the discretion. The court has to exercise discretion in an appropriate and judicious manner. The purpose and the local investigation of the rule line is to have to the evidence from the spot itself to have a correct and proper understanding of the dispute between parties. Local investigation report submitted by the commissioner enables the court to make a correct assessment of the evidence on the part. Then the court takes an opinion and critical on the part requires verification. It would be just a reasonable to issue a commission. The commission at the instance of the one of the parties find out and then no position to poverty can be issued in enables the party seeking appointment of commission is gather evidence. But there is an existing dispute regarding the identification of the poverty. The court has necessary to issue a commission in this assessment of the survey. Otherwise, it would be a highly difficult report to comply with, highly difficult for the court to completely and effectively resolve the dispute and then issuing the commission would not amount to correction of evidence. Commission for the same purpose can be issued proper after the parties yet to claim evidence. In the instance case, I am of the opinion, having reviewed the opinion of the local necessary, and the last trial would erroneously reject the party commission. This is also good for injection. Next case, now. Actually, very good page number 10. 2018 362. This is with regard to the declaration. In the matter, to give matter, there are 10 matters. Not injections of man, there is no dispute regarding position laid down by the Supreme Court. It is an undisputed fact that the power under Article 227 is wider than the one HIGHCOURT under Article 226, and it is an undisputed fact that the power of the human is not subject to the some technicalities of the procedure discretion which are to be found in the such a regime. In order to resolve dispute between the parties and in order to justify both the parties, it is essential to appoint a commissioner by appointing a commissioner by local respective. No provisions will be barred. On the other hand, it will be helpful to render the complete justice. I am therefore of the opinion that the order will be in this case of but it is not in which declare it. But I need to do page number 16. 2012 4A and DT. This case matter. First we'll go to last page matter. Paragraph number 4. An advocate commission is appointed under Article 229 procedure. Inter alia for eligibility in any matter in dispute. The itself states the claim of the claim for injection made by the respondent in the case and there is only one way to, and that he is being prevented by the petitioner from using the can section. Any matter of the evidence in this regard, we are not able to go to render because finding these that. Therefore, the situation is going to certainly fall within the expression of the in this, my opinion, would not help gathering of evidence. It only helps the court to ascertain certainty and whether there is a motive or there is any other law. Indeed, as according to the application, the facts of the present case, no harm will be brought to the interest of the co-petitioner. It is to be the case of the land and exclusively belongs to them. That there is the other leading way for the inspector of the applicant. The truth can be more effectively and in the other case of they file their counter in they also getting it necessary for in this fact the course of these not only gathering evidence process.
Why don't you file a petition to the Manda survey for demarcating your property? Survey number, the survey number. There is boundary dispute between you, both of you. Why the field court? You have to file petition to the Manda surveyor by paying amounts to the revenue department. There is position is there for demarcating of the properties by the revenue authorities. You have filed petition. Then you have to file petition. No, sir, you have filed application for the demarcation of your property to the revenue authorities. There is no one prohibited for you to file application for your. There is no dispute, sir. You have filed a petition for injection suits. They are interfering. They are saying they are interfering. We are accepting your dispute. Property dispute, you have to file. Show me your demarcation of land, sir. Competent authorities, sir, and Manda surveyor, sir, for demarcating of land. You not surveyed your land. After filing of the filing counter, you have said. Yes, sir. That.
In the absence of the counter, they are admitting.
Yes, sir. What you have? Yes, sir.
These are only for localization of it, but not for demarcation.
Yes, sir.
Thereafter, it is a suit for perpetual injunction filed against these defendants. These respondents. Thereafter, he files an interlocutory application for injunction in which he doesn't in the plaint. You not just may kindly see the plaint at page 25. There is no schedule in the plaint itself.
Then
you might kindly see the plaint starts from 21 to 26. 25 and 26 are important. This cause of action, limitation, court fees, jurisdiction, and prayer at 25. 26, there's verification. There is no schedule in the plaint itself.
No schedule, sir.
No schedule.
Show me schedule then. Your schedule.
They don't file here. How would we know whether it's amended or not with
Yes,
us?
sir. Then you have filed producer. Then one company has 6 time to produce the schedule of property in the suit. Post after 3 weeks.
Not to enter, but in already there is another.
That may be extended. They are seeking a stay of their own, so I don't mind with it.
No election till then. Last one, say that.
Item number 52, Praveen Kumar Challa, Muhammad Abdul Samad, Muhammad Ilyas.
Yes, sir.
Because of the entire but the duties with regard to only one survey number. It's spoken in the initial order. Court has directed them to file a separate. So the third party cannot get in the located in party.
In the month of June, when this matter is taken up in the court room and appealed by the respondent, none of the respondent, passed over the matter, was for the respondent. Afternoon also, none of it was the respondent. Then the reason I have granted into models.
Therefore, the expedite petition was filed without notice first. Then we don't know about that.
Listed, this was listed in all this, but you have none of it was the respondent. That's why I granted into models.
There are the record.
We don't know.
Subsequently, I filed vacant petition and I came on the record.
No one appealed to the respondent. That's why I granted into models. It's told the May, they granted by the court below to Not survey, that's why I'm running into matters. Where the respondent comes for petitioner.
Last occasion, he requested personal inconvenience, I didn't object. But this court had passed over the matter, then of trial. In this matter, it got I think they mentioned it.
CRP filed against which address?
In the indictment,
Okay, take on the petition. The respondent, general petitioner, post orders after 3 weeks. And post orders are laid on the place. Urgency, you have urgency. But here,
my only request was being a. Let there be the order in respect of the disputed survey numbers. As regard to the
I
other.
agree. The original consular petition cannot modify the orders. Sir. After hearing both of you, and pass on finally, pass on 2022 CRP, pass on finally.
Problem is in morning survey number, they want. Great difficulty.
Okay, post of 2 weeks. Sir. Post of 2 weeks.
Irrespective of whether it comes or not, because he knows that there is an order.
Yes, sir, that's right. No consular petitioners, take on the respondent, post orders after 2 weeks.
Item number 53, Surendra Reddy, KB Monica, sir.
So, momentum is ascending this long time. Before vacation, I put it to virtual mode and physically. But directed to listen 711, sir. So, what is supposed? What is the date of 7? Huh? Not Monday, sir. Dimarco Maldacqua. Yes, yes. What the training? Which was better? Okay. I'll put 1 week, sir. Not tomorrow, sir. Again, another case, not tomorrow.
They are obtained stage. So 9 should be.
Actually, posted for orders. Uniform capital order day, okay, vacation, before vacation, I have uniform capital orders. Left tomorrow, sir, not tomorrow. I will. Okay, Commission 6 and for left tomorrow. Nothing to left tomorrow, nothing like that, sir. That will, other than that, left tomorrow.
Item number 54, please, Anushka.
My lords, I am for the petition, my lords. May I please, my lords.
Yes, sir.
My lords, this is in a CRP challenging the impugned order of IA 1382 of 21, where the learned trial judge has passed a status quo orders, but did not order for a Rule 3 compliance under Order 39, my lords. And when we have challenged the same, the learned trial judge has greatly
1 minute, sir. 1 minute. Which for respondents?
My lords, respondents Palle Nageshwar Rao Peru is being reflected, but they have not represented, my lords.
Well, then I should have is not clearly mentioned. Okay. That is the problem.
For the legal heirs.
Not visible. Parana has not appearing. I'll spin the outline. This long, like 2 times, cannot appear. Last occasion requested for time. What is the case, sir?
Lords, we are the respondents in the lower court, my lords. The respondents are the plaintiffs. They have filed for a specific performance suit. And in that, the learned trial judge has passed a status quo orders. But the learned trial judge has not ordered for the Rule 3 compliance, nor the respondent plaintiffs have complied with the Rule 3 compliance. So we have challenged the same. And the learned trial judge reasoning is
Not properly analyzing, sir. That is problem. We have to come to the.
My lords, can it be posted tomorrow so that I will appear physically, my lords? Today there was a medical emergency, so I couldn't appear.
Welcome to respondents. 6 time. Post after 2 weeks.
Oblige, lords.
Item number 55. M. Abner Reddy D. Gita.
My lord, I beg to appear for the petitioner, my lord, Mr. Abhinay Reddy.
Yes, sir.
My lord, the point for lordship's consideration in the present CRP is this, my lord. The brief background of the case is this. The suit was filed for injunction, my lord, by the plaintiffs. In the suit itself, my lord, the pleadings in the plaint itself say that they were the caretakers of the owners of the property. They have taken care of those owners for long standing for more than 30 years. And they allege that the owners had orally told them that there was some will that is made in their favor. No date, no copy of the will, no witnesses, nothing was pleaded in the plaint, my lord. For the defendants, my lord, filed written statement saying that the owners had already entered into a registered will in their favor. The property was mutated. Property is in the ownership of the defendants, my lord. Basing on that, my lord, initially injunction was granted. Thereafter, the court below dismissed the IA and vacated the injunction order on the ground that they have no legal right. The plaintiff's admission that they're caretakers and alleged to be in a will which they've never produced before the court, and defendants produced the registered will in the mutation records. So therefore, the injunction was vacated, my lord. The defendants had filed a Order 7 Rule 11 fundamentally on a legal issue, my lord. It's covered by more than 3-4 Supreme Court judgments, my lord, on the ground that when you don't have a legal right, as per the pleadings in the plaint, there is no cause or right to sue. When there is no cause or right to sue, my lord, it would fall under Order 7 Rule 11A, the first one, that there is no cause of action for the suit, my lord. So Order 7 Rule 11 was filed, my lord. The court below, having held that they don't have a legal right in one IA, in the other IA, my lord, has held that the question of whether they have a right or no, we'll see it at the time of trial, my lord, and dismiss my IA. Against that IA, my lord, we are before lordship, my lord. Undisputed facts of the case are the plaintiffs admit that they're caretakers. Honorable Supreme Court, my lord, in more than 3 cases held that caretakers cannot claim long-standing position. That position is only being given gratuitously, and since they've received salary throughout, there's no legal right they have on that position, my lord. All those judgments were not considered when I placed them before the court below. And the second point for consideration, my lord, the plaint itself doesn't make out any cause of action. They've been staying here for almost 4 years since they filed the suit also. So, therefore, my lord, Order 7 Rule 11 ought to have been allowed as my submission, my lord. May I take your lordship through the pleadings in the case, my lord?
It's a plaint copy. Show me the plaint copy. Plaint.
No, my lord, I'll take your lordship with the plaint, my lord. My lord, the plaint, my lord, it's on page number 52, my lord.
Cause of action,
my lord. Lordship, may please come to 53 for a moment, my lord. 2-3 paras only. I just want to show your lordship before taking to the last page, my lord. Para 3, my lord. Lordship may kindly see, because this is relevance to the other Supreme Court judgments. Para 3(1). It is submitted the plaintiffs 1 and 2 are appointed as caretakers of so and so. They both are senior citizens. So the admission is the caretakers. Then lordship may kindly see, my lord. Para 3, my lord. Para 3, subpara 3, regarding their own right, my lord. The last of the lines, my lord. That taking into consideration of the services rendered by plaintiffs 1 and 2, the said so-and-so had executed a will bequeathing the said scheduled property in favor of plaintiffs around 2014. The will is in the custody of defendants. That is their case. No date, no witness, nothing. So no legal right. Now please come to the paragraph of cause of action, my lord. That's on page number 55, my lord. Para 4. It is submitted that the cause of action for the suit arose in the year 1991 when the plaintiffs were appointed as caretakers, and also in 2014 when the so-and-so had executed a will in favor of the plaintiff and bequeathed the suit scheduled property, and also in 2015 when so and so had died and the will executed by him came into force. And 18/11/2020, when the defendant addressed the letter directing plaintiff to vacate and hand over the suit schedule property. On so and so, an henchman of defendants came to suit schedule property and threatened the plaintiff to vacate. Now the will of the defendant, my lord, defendant number 1 and 2, 1 is a trust, my lord, for charitable purpose. 2 is the person who runs the trust. The will that the defendants are relying upon is the 2012 registered will that came into force immediately when they died. Mutation was done. Everything is running in their name. They've been receiving salary also. So this is the cause of action set up by them, my lord. Now, Lordship may kindly see the IA, my lord, that we filed for the court below. IA is on page number 39, my lord.
Yes, sir.
Para number 1, 2, and 3 are general in nature, my lord. Para number 4, my lord. Then, my lord, para number 11, my lord. That's where the legal arguments are, my lord. Para 11. I humbly submit that respondents, may I read it, my lord?
Yes, sir.
I humbly submit that respondents plaintiffs have admitted that they are merely caretakers of the property. A caretaker employed to look after the property can never acquire interest or legitimate right in the property irrespective of the long position. The respondent plaintiff being caretaker are under obligation to hand over the position forthwith on demand. I repeat that even by long decades of position, the respondent plaintiff would not acquire a right or interest in the property as they were allowed to stay in the premises gratuitously. In the absence of any legal right, there cannot be a right to sue. And in the absence of right to sue and cause of action arising, no relief can be sought and plaintiff is liable to be rejected. I humbly submit that referring to the above provisions of Order 7, Rule 11 and the settled law, the plaintiff is liable to be rejected when the plaintiff does not disclose the cause of action, no legal legitimate right is affected, plaintiff does not possess a locus to file the plaint. This exactly fits into a Supreme Court judgment where a similar caretaker claimed a right. Honorable Supreme Court said that Order 7, Rule 11 ought to be allowed because there is no legal right for them to sustain this suit. It's abuse of process of law, what the Supreme Court held, my lord.
The judgment. Show judgment.
Yes, my lord. May I take your lordship through the judgment straight away, my lord? No, my lord, the judgment I'm relying upon is the, my colleague will pass it on to your lordship, my lord. The 2022 13 SCC 649, my lord. It's a judgment of Himalaya Wind Trade Private Limited, my lord. Your lordship has got it, my lord?
Yes.
My lord, it's a very short judgment, my lord. May I read it, my lord? Yes. Para 1. The appellant defendant had approached this court assigning the order passed by the learned single judge and confirmed by the High Court on the application filed at his instance on Order 7, Rule 11. The facts on record are not in dispute. The appellant defendant initially entered into an agreement to sell of subject property. Formal deed of conveyance, finally sale deed was shown. So his right of ownership of subject property in question became absolute. Respondent plaintiff filed a suit with the following prayer. Declaration: the plaintiff is a lawful occupier as caretaker, servant of the sole owner of the scheduled property and occupier and adverse possessor of the Schedule B property. For permanent injunction, disdaining defendant to disturb or evict the peaceful possession of plaintiff otherwise than due process of law. Lordship may kindly come to para number 7, my lord.
Yes.
After we heard the counsel for the parties and taking into consideration the material on record, in our considered view, the trial court has committed a manifest error in appreciating the pleadings on record from the plaint filed at the instant of respondent number 1. Plaintiff, who is a caretaker servant, can never acquire interest in the property irrespective of his long position, and caretaker servant has to give position forthwith on demand. So far as the plea of adverse position is concerned, as it lacks material particulars, the plaintiff does not disclose the cause of action of institution of a suit. In our considered view, order of the learned trial judge, which has been confirmed by the High Court impugned in instant proceedings, is not sustainable in the first principles of law. Consequently, appeal succeeds and is allowed. Order of the High Court is hereby quashed and set aside. Para 10, my lord, since we have rejected the plaint in presence of the proceedings initiated, we direct respondent one plaintiff to hand over the vacant peaceful position of subject property in question free from all income within 3 months from today. Which is very identical. It is plaintiff's case that the caretakers. And I have mutated my lord, the second judgment, my lord, what I am relying upon is this. My lord, it is Arvind. My lord, it is 2012, 2022, 12 SCC 641, my lord. The relevant paras are para 15, 17, and 20, my lord.
Para 15.
Para 15, my lord, comma, 17, comma, and 20, my lord. I'm reading para 15, my lord. May I read it?
Yes, sir.
It could thus be seen that this court has held that reading of the averment made in the plain should not only be formal but also meaningful. It has been held that if a clever drafting has created the illusion of cause of action, and a meaningful reading therefore would show the pleadings are manifestly vexatious and meritless in the sense of not disclosing a clear right to sue, my lord, then the court should exercise its power under Order 7, Rule 11. It has been held that such a suit has to be nipped at the bud at the first hearing. Lordship, please come to para 17, my lord. It could thus be seen that the court has to find out as to whether in the background of the fact the relief as claimed in the plaint can be granted to the plaintiff. It has been held that if the court finds that none of the relief sought in the plaint can be granted to the plaintiff under law, because the court held here that injunction cannot be granted to him. The question then arises whether such a suit is allowed to continue or go for trial. This court answered that the said question by holding that such a suit should be thrown out at the threshold. This court therefore upheld the order passed by the trial court rejecting the suit and that the appellate court thereby affirming the decision of the trial court. This court set aside the order passed by the High Court wherein High Court had set aside the concurrent order of the trial court and appellate court and had restored and remanded the suit for trial of the trial court. Then the last para number 20, my lord. It could thus be seen that this court has held that power conferred on the court to terminate a civil action is a drastic one, and conditions enumerated on Order 7, Rule 11 are required to be strictly adhered to. However, Order 7, Rule 11, the duty is cast on the court to determine whether the plaint discloses the cause of action by scrutinizing the averments in the plaint, read in conjunction with the documents relied upon, and whether the suit is barred by law. This court has held that underlying object of Order 7, Rule 11 is that when the plaint does not disclose the cause of action, the court would not permit the plaintiff to unnecessarily protract the proceedings. It has been held that in such case it will be necessary to put an end to the sham litigation so that further judicial time is not wasted, my lord.
Yes, sir.
The third judgment that I am relying upon, my lord, is this. My lord, the third, I'll just take it and show this one. No, illusion, congratulations. No, my lord, third one is 1977, 4 SCC, my lord, 467. Your lordship might have read this case number of times, my lord, very classical case, but this is honorable, this is V.R. Krishna here, my lord, on illusionary, creating illusion of pleadings, my lord, para 5, my lord.
Yes, sir.
We have not the slightest hesitation in condemning the petitioner for gross abuse of process of court repeatedly and unrepentantly restored to. From the statement of fact found in the judgment of the High Court, it is perfectly plain that the suit now pending before the First Municipal Court, Bangalore, is a flagrant misuse of mercies of law and receiving plaints. The learned municipal must remember that it's on a meaningful and not formal reading of the plaint. It is manifestly vexatious and meritless in the sense of not disclosing a clear right to sue. He should exercise his powers under Order 7, Rule 11, taking care to see that the ground mentioned therein is fulfilled. And if a clever drafting has created the illusion of cause of action, nip it at the bud at the first hearing by examining the party searchingly under Order 10 CPC. An activist judge is the answer to irresponsible lawsuits. The trial court would insist imperatively on examining the party at the first hearing so that bogus litigation can be shot down at the earliest stage. The penal code is also resourceful enough to meet such men and must be triggered against them. In this case, the learned judge, to his own cause, realized what George Bernard Shaw remarked in the assassination of so and so. It is dangerous to be good. I'm just leaving it there, my lord. On the issues of law, I'm just putting it, my lord. The fourth case that I'm relying upon, my lord, is this, my lord. It's 2012. 5 SCC, my lord. Page 370. The relevant paragraph is paragraph number 97, my lord. Lordship may kindly see the head note A, my lord. Head note A is that property law, position, classes of position, position in consequence of proprietary interest, position in consequence of licensary or contractual rights, gratuitous and purely permissive position, my lord. I am emphasizing on that, my lord. Para number 97, my lord.
Yes, sir.
Para number 97, my lord. Principles of law which emerge in the case are crystallized as under. No one acquires title to the property if he or she was allowed to stay in the premises gratuitously, even by long position of years or decades. Such person would not acquire any right or interest in the said property. So if he is not having right or interest in the said property, my lord, continuing the suit would be against Order 7, Rule 11A, my lord. That's my humble submission. The next paragraph, caretakers and watchmen and servants can never acquire interest in the property irrespective of long position. The caretaker or servant has to give position forthwith on demand. Courts are not justified in protecting the position of caretaker, servant, or any person who is allowed to live in the premises for some time either as a friend, relative, caretaker, or servant. The protection of court can only be granted extended to a person who has valid, subsisting rent agreement. They don't have that. Lease agreement, they don't have it. License agreement, they don't have it in their favor. The caretaker or agent holds property of the principal only on behalf of the principal. He acquires no right, interest whatsoever for himself in such property, irrespective of long stay or position.
Yes.
They summed up only on this issue, my lord. The next judgment, my lord, is 2012. 2012 6 SCC 340, my lord, A. Shanmugam.
Yes.
No, my lord, the relevant paras are 43.6, my lord, and 43.7. This has been rendered by the same Honorable Judge, Justice Dalveer Bhandari. The earlier judgment also was rendered by the same judge, my lord. Just for the continuity, I am referring his name, my lord. 43.6, my lord. The watchman, caretaker, or servant employed to look after the property can never acquire interest in the property irrespective of the long position. The watchman, caretaker, servant is under obligation to hand over the position on demand. According to the principle of justice, equity, and good conscience, courts are not justified in protecting the position of watchman, caretaker, servant who was only allowed to live in the premises to look after the same. The watchman, caretaker, agent holds the property of the principal. The same thing was stated once again, my lord. After that, my lord, the next case, my lord, on the similar lines, my lord, next case is the 2017 2 SCC 759.
Yes, sir.
My lord, para number 14, my lord. This is on the caretaker servant on similar line, my lord, different para 14. That the person holding the premises gratuitously or in the capacity as a caretaker or a servant would not acquire any right or interest in the property. Even long position in that capacity would be of no legal consequence. In the circumstances, the civil court was right and justified in rejecting the prayer of the interim injunction and the decision, which is very similar. In my case, he rejected the injunction order on that ground only. And the decision ought not to have been set aside by the High Court. He therefore allowed the appeal, set aside the judgment and appeal, restore the order, so and so. In this case, the injunction order was not granted, my lord. High Court reversed it. Supreme Court said caretakers cannot get it, my lord. Therefore, injunction order was granted, my lord. Now, to the extent the impugned order, my lord, may I take your lordship to the impugned order? This is the law, my lord. Legal position is caretaker, servants and all cannot claim position. Their plain reading shows they stated their caretakers only. An unknown will claim to be in defendant's position. Defendant produced a valid registered will, mutation is done, They are legal owners, my lord. Now, what the court has held, my lord, Lordship may kindly see the impugned order for a moment, my lord. It's on page number 9, my lord.
Yes, sir.
My lord, page number 12, my lord. I'll just quickly take your lordship through the relevant paras, what has been stated. Page number 12, para 2.2, my lord.
Yes.
That this is my case that you set up that the caretakers and all, it's admitted position, my lord, that was extracted. Then page 13, my lord, it once again stated that the plaintiff itself stated that he is a caretaker and he was put in position as a caretaker, my lord. Then Lordship may kindly, then page number 14, my lord, para 2.6. Then because the plaintiff quoted about a will but never produced it also before the court. Then, my lord, Lordship may kindly see the page 16, my lord, the issues of argument. This is what is put across before the court. I'll just read these 5 lines for Lordship's consideration. 2.8. The respondent plaintiff seeking injunction and judicial approval of their position have not pleaded with clarity for this court to even adjudicate upon the legality of their position in the suit schedule property. In the absence of sufficient details or right to sue being disclosed in the pleading, they will not arise any issue and this court is empowered to reject the plaint, the threshold for being frivolous and abuse of process of law. It appears that the plaint does not disclose contents of the alleged will or its date of execution or details of the witnesses or the bare minimum indicate how the first respondent herein gained knowledge of the alleged will and that whether it was hearsay information or personal knowledge. No part of untruthful story carried out to the court by the plaintiff is worthy of the credence. Plaintiffs have made a desperate attempt to outwit this court by referring a non-existent will and have made a half-hearted frivolous statement that the position of the alleged will is with the defendants, my lord. Now, Lordship may kindly come to page 17, my lord. Page 17 is the paragraph on those legal submissions as stated by the Honorable Supreme Court, my lord, that has been pleaded. Now, para 19, my lord, I'm sorry, page 19, para 2.11, my lord. We had filed this judgment before the Honorable Supreme, before the trial court, that the Honorable Supreme Court has held that caretaker, so the law was placed before the Honorable Court, my lord. Then the issues were framed by the Honorable Court, my lord.
Page 28.
Page 28, my lord. Para 6, my lord. This was the issues that were framed. Rightly so, my lord. Then, since order 7 rule 11 is extracted here, my lord, I'm just reading it from para 8, my lord. Before going to answer this point, the provision of order 7 rule 11 is extracted. Rejection of plaint. Plaint shall be rejected in the following cases, where it does not disclose the cause of action, my lord. I'm relying on that. And the case that I relied upon is Himalaya case, which exactly fits into my case, my lord. Then, Lordship may kindly see, my lord, the finding, they extract all the cases, my lord. But no reasoning or analysis on the cases, my lord, how it is not applicable. Please come to para 14, my lord. That as per the precedent referred above, the cause of action is the bundle of facts and question of fact and law. Therefore, it cannot be decided in an interlocutory application. Order 7 rule 11 itself says when there is no cause of action, it is an interlocutory application only, my lord. In particular to the case of caretaker, servant, position, legal position. Unless a full-fledged trial is conducted, that the other contention of the petition of the defendant is that no will executed by so-and-so as alleged to respondent in respect of scheduled property, that the said fact cannot be decided in the present petition. Here is the plaintiff who doesn't have a document, doesn't have a legal right, goes to the court, my lord, and then seeks this. And the court saying that we'll decide this thing in trial in my humble submission is untenable, my lord. The present petition it can be decided in the full course of trial that if the respondent plaintiff failed to prove the alleged execution of sale by so-and-so, the court also says alleged execution of the sale, my lord. It's not a sale, my lord. Execution of a will, typographical error, my lord. They lost the suit. As such, argument of the learned counsel of petition defendant is not sustainable, and the contention raised by the petition defendant with regard maintainability of the suit as a true owner, not as a question of fact. Not is the question of fact. As such, at this stage, so he admits that I am the true owner. There is no dispute about it. As such, at this stage, this court should not go into the merits and demerits of the suit. It is a tribal issue. Therefore, arguments the learned counsel of the petitioner defendant is not sustainable. Further, the facts of the case law relied upon the counsel for petition defense are different from the facts case on hand. As such, they are not helpful to the petitioner. My lord, how are they different? My case identically fits into the Himalaya case, fits into the other cases also. When the plaintiff itself is saying that his position is as a caretaker, doesn't have any other legal document, defendant puts up all his documents. So therefore, in my humble submission, the trial court's finding that the case law is not applicable is erroneous, and facts don't fit in the erroneous. And for the trial court, having held in the injunction matter that they don't legal right, he held that there's no legal right and vacates the order. And here he says that we'll decide this in a tribal issue. Is my humble submission is not is erroneous is my submission, madam. So
Election of demand, where is the other copy?
Injunction order, madam.
Yes, sir.
Injunction order is there.
Last week, it's not a part of the record.
My lord, I'm sorry, in this CRP, I think so that injunction order has not been filed. My lord, may I pass it on in some time? May I read that portion of the para, my lord? Or can I screen it?
Okay, sir. Third.
My lord, I'm sorry, my lord. Can I screen it? My lord, if your lordship permits, can I screen that order, my lord? Can I screen it? I'll pass on the copy also, my lord.
Off-screen, sir. I cannot read it. I have small screen.
No, I understand. I'm sorry. I'm sorry, my lord. So, my lord, I'll just pass on the order and then place reliance on the order so that I don't know. I want to take the court through the same order immediately, my lord.
Yes.
So, would your lordship pass over this matter, my lord? 230 may show that. Can I give the hard copy, my lord?
Okay, continue. I will continue. I will.
My lord, deeply obliged, my lord. I'm just reading that order, my lord, injunction order. My lord, that is in page 8, my lord. Even as on date, the trust is active in providing services in line with the objects and vision that the said petitioner plaintiffs herein were being paid by the trust. It is pertinent to point out that mutation of the said property in the name of the trust has also been done in the revenue records by GHMC. That Mr. So-and-so was only caretaker of the property, and the petitioner plaintiffs have no independent right whatsoever in the suit. They were only permissive occupant as caretakers in so-and-so. The petitioner plaintiffs failed to take proper care of the suit premises. The trust was forced to terminate their services and to vacate the premises, and wherein they are permitted to stay during the employment of the caretaker. The trust terminated the services of petitioner and became so-and-so one. I'm reading para 3A, my lord, that the contents of para 3 of the affidavit is admitted to the extent that petitioner plaintiff was appointed as the caretaker of the suit property and the plaintiff was appointed as a helper. As stated in preliminary submission, the plaintiff was used to occasionally aid the husband maintaining the such suit property, my lord. My lord, the issues are framed on para number 5, my lord, page number 14. Point number 1, my lord, which is the main issue. My lord, on page number 19, my lord, para 11 is the main conclusion, my lord. That in the case on hand, it is main contention of the petitioner that they rendered services to the masters due to which the master had executed a will in respect of petitioner's scheduled property. But the petitioners neither mentioned the date of the alleged will in the affidavit nor filed a copy of the alleged will. Since the petitioners have failed to file the copy of the alleged will to support their version, they are absolute owners of the petitioner's scheduled property by alleged will. In view of the case law relied on by the learned counsel for respondents, this court feels that the petitioners being caretakers are not entitled for injunction as prayed for in the petition. However, to appreciate all facts asserted by the parties, a full-fledged trial has to be conducted. At this stage, there is no hesitation to hold that petitioners have failed to prove prima facie case, balance of convenience in their favor. Therefore, if temporary injunction is not granted pending suit, no irreparable loss will be caused to the petitioner. The comments made in respect of the document on any aspects are restricted to the IA. So, therefore, since they don't make out a case for injunction and no documents are filed to show their prima facie case, the injunction order has been vacated.
Yes.
So the court below, my lord, considering the case law cited and the facts which are in a very narrow compass, an undisputed fact, appointment of the caretakers, they took care for 30 years, they used to live in the outhouse. After the demise of those owners, my lord, they themselves, with a registered will, gave it to a trust. Trust got it mutated in their name. Trust is paying them salaries even after their demise for few years. trust wanted them to vacate those premises. When they sent a letter asking them to vacate the premises, this was during COVID time in 2020. I understand, those times, things were slightly different. So the court also, while granting injunction order, had said that in COVID times, that's what they pleaded in the plaint also. COVID times, we should not be allowed to go out. Now it's almost been 3 years now, my lord. So,
Yes.
therefore, continuance of the suit, my lord, in my humble submission would not survive as there's no legal right, my lord. I'll file a short note if your lordship permits, my lord. I was told written arguments are also on record. Your lordship.
Yes, sir. Now it's also.
Yes, my lord. This case, if your lordship permits, should I file it as small book, my lord, or the loose copies that have been given to your lordship? May I file a small book, my lord, case law, if your lordship permits?
Give it. Yes, madam.
I'm obliged, ma'am.
Of the case, I want to clarify.
And use mic, madam. Otherwise, you will not hear.
Going into the merits of the case, I want to clarify 3 issues. Whether the present petition is maintainable or not. The first and foremost thing, the suit is filed for an injunction. It is not a declaration of right. But the suit filed for injunction, only 3 factors to be considered: democracy case, balance of evidence. We have proved all these things before the lower court. Whatever it will be, the injunction order is under appeal before the appellate court, under CME. So that cannot be looked while the appeal is pending before the High Court. That is one thing. And the second thing is the petition order 7 rule 11 dismissed on the ground that there are as many as 13 judgments passed by the Honorable Supreme Court confirming the latest judgment in 2021 that order 7 rule 11 only the cause of action and the legal any bar of law. Only 2 things has to be considered. In this case, the cause of action in the plaintiff you lost seen on 1811, 1611, they sent some antisocial elements to forcibly vacate the petitioners, respondents hearing. And then one advocate. Actually, I don't want to say the name and of those things, but these are the part of the record, including phone number. Threatened them with the dire consequences that police will come and make you to neck out and put criminal cases. And the third thing, they threatened that the son of the respondents will not working in their company. So they threatened to remove from the services. These 3 threatenings they have made before issuing the letter. And after that, on 18/11/2020, they issued a formal letter the mark in the lower court but my learned friend have not filed any documents before this honorable court. So I may be permitted to file all the documents along with the written documents.
Before starting of senior cost arguments, you have to mention that you want time to file documents.
No. Just because.
How many here in half an hour? You want time to file documents?
Because actually the petition for order 7 rule 11
will take it account only plaint and plaint documents along with the plaint only.
Yes, and cause of action. He has taken only 2 grounds. The principal ground is cause of action. The cause of action, that is what I told already, the threatenings.
Just I want to see the notice of the response, not filed along with this. I have seen no notice filed by the petitioner.
Yes, Yes, 18/11/2020 in the Munamga Victorian Devanaga, we have 20 numbers source on the Parivari Vasti Kromover Master Attention Jergindi. He used Sri Kasina, the Nagasura, Similar Samuprasa, Dharma Change, and Vasa Taramunamuga, trust to our final percolabate Indiki, someone in Chinapanubu, current to Marie Chadichunaru. If you want Sri Kalyan Chakravarti, Amsani Pujogi, Inti Babu, Tanki Children, Angas Jergindi. ఆయన మీరు తెలియజేసిన ప్రకారం ఇల్లు చాలా అస్తవ్యస్తంగా ఉన్నది. ఇంటి పైన చెట్టు కూలి గోడ ఒకటి కూలి ఉన్నది. మరి ఇంటి శుభ్రత ఏమాత్రమూ పట్టించుకున్న దాఖలాలు కనిపించలేదు. ఇందు మూలంగా మిమ్మల్ని ట్రస్ట్ సభ్యులు నిర్ణయం ప్రకారం ఇంటి సంరక్షణ బాధ్యతల నుండి తొలగించడమైనది మరియు మీరు పైన పేర్కొనబడిన ఇంటిని అపరివారంగా తక్షణం ఖాళీ చేసి ఇంటి తాళం చెవులు మా ప్రతినిధి శ్రీ కళ్యాణ్ చక్రవర్తి అమృతాంజన్ ఉద్యోగి గారికి అందజేయవలసిందిగా కోరడమైనది. This is the written letter, the cause of action for the. This is the written cause of action. Besides that, the threaten is through antisocial elements and through advocate. This is only suit for injunction. Whether this cause of action is sufficient or not for filing the injunction suit, that court decided. Then the title. Now the respondent petitioners hearing, they are trying to prove their title in injunction suit by Order 7 Rule 11 petition. They are claiming through a will which was not seen the light of the day till today. And so much of cloud is around the will. And the profounder is the beneficiary. The first thing. And the second thing is the property entrusted to the trust, and the managing trustee has every right to sell the property and distribute between the relatives. It is unknown to law. So many issues and so much cloud is there. So the learned court did not get into those things and just decided Order 7 Rule 11. At this juncture, it has to be taken plain terms as per the cause of action, the ground under Order 7 Rule 11. This is the cause of action. And I have mentioned the phone numbers and advocate name and antisocial elements in the other petitions and my arguments, but here I have not mentioned. And the second thing, legal right. It is if it is barred by law. Here, the judgments, all the judgments my learned friends suggested to this honorable court, is it law right or law? If I am doing any illegal act which is barred by the court to grant any relief, that can be treated as a part of law. But it is a matter of right. It is not a law. He is claiming that he has a right as a true owner through the will, which was not even seen the light of the day, which is mandatory under Section 68 of the Evidence Act and Section 3 of the Transfer of Property Act. It should be confirmed before the court of law. Till today, it was not done. Behind my back, even if we get it done mutation, that will not give any right under Section 68 of the Evidence Act. So all these facts has to be looked into at the time of trial, not at the time of Order 7 Rule 11. Under those contentions, the said petition, which impugned order before this honorable court, was dismissed. And the decisions which my learned friend put forth before this honorable court, even he put forth all the decisions before the lower court. All the decisions were denied in toto, stating that it is not a question of right. See, the Order 7 Rule 11, it is barred by law. Then only Order 7 Rule 11 can be applied. But the judgments is not a law. The judgments depends upon the different facts of the case. On its own case, not here. He is claiming the titles through will. Admittedly, the will was not seen the light of the day. Just because it is registered, which is not required at all as per law. How can the court can declare his title, treating him as an owner of the property? So that is the reason, even in the injunction petition, the lower court clearly stated that this is not a matter of trial, matter of injunction petition. This is a matter of trial. Yes. And so far as 30 years of possession and my right, what I am claiming, the entire land is 2,500, more than 2,500. The owners, they have one son, they are predeceased before them, Millard. He is working in, he was working in VHR. In the year 1994, he died. Actually, in the year 1991, they have employed these petitioners, plaintiffs and the respondents as the caretakers of the person, not the property. That too, not the second petitioner. Only the wife was appointed as a caretaker to the wife of the owner of the property at the rate of 200 rupees per month, Miller. And they have they have continued their services 30 years. After that, they blessed with 2 children. At that time, they said, we cannot go on with this meager salary. We want to vacate the house and we want to go out for fetching a job. Then, Milord, they said, no, the outhouse which is there, including car parking, this property is for you. We will execute a will in your favor. Don't leave us because we have nobody with us. We are the old people. So that time, they have only promised. Thereafter, in the year 2014, he wrote a will and he showed and kept it with him. Because the will come always after the death of the person. How can I will take from my Malik the will? That is my condition, the will is with them. Whatever the will they are claiming, that is in 2012. And that will, he has not filed any documents, sir. I will file all the documents, it will show the what is there in that will. Without documents are not supposed to
starting. You got to mention, madam.
But because from rule 11 but these two grounds, whether this it is a question of law or question of right.
Yes.
So if it is a question of law,
okay, one time I'll grant you time. Go to the next case. So cost per response 6 times. File counters post after 3 weeks final.
I file counter just I have to file a document.
Counters.
Only Millard.
Counters follow record, madam.
Then I will file.
Okay.
Investor number is there, Millard. Because yesterday my learned friend informed me that they are mentioning the matter. It is coming on Tuesday. So immediately I file the counter.
The CRP, the 2022 CRP, my lord.
Yes, sir.
I don't want to say anything, but Order 7, Rule 7 says plaint has to be seen. I filed the plaint along with the. I can even leave it there, my lord.
But you are not filed medical along with the plaint, sir. You are not filed medical along with the plaint. What they filed, respondent filed.
Yes.
My lord,
Not the plaint, but not filed along with.
I'm sorry, my lord. They filed the driving license, Aadhaar card, my lord. These are documents, but they can file it, my lord. I have no objection with that.
I have seen not filed documents. I have noticed
No, assuming that the grave documents which are missed out, let them file it, my lord. I leave it to the honorable court. I'm not objecting for that. Aadhaar card, driving license.
No, I have 6 and 7 of the 6 and 6 elements are 10/4/2014. Copy of letter addressed to the plaintiff number of vacating the real property.
Yes, my lord. That's all.
Again, my family mention is Aadhaar card, madam. That is.
Yes, that is it.
Wrong way.
It was changed in the.
Yes.
I will make it Millard. These documents were marked Millard in the election item. These documents.
Okay, sir. Post after 2 weeks.
Yes, my lord. Would your lordship give any particular date, my lord? Any particular date?
21/11, sir.
Deeply obliged. Thanks. Deeply obliged.
Booklet also. Also filed booklet meantime on that date.
I'll file, ma'am. I'll file. Deeply obliged.
Item number 56, B. Santosh, DP for arbitration, K. Vishal Singh Gupti, K. V. Ritik Reddy.
District Collector, Mandalina Officer, Secretary, Education Department, with the DEO. What is school building?
No, sir. They have to do a school building. Regard to the schedule A property. That issue has been decided. Now I have petition to incorporate B schedule property. Which, as they are the party in the school, we have made them the performer party to the present we have. They have no rights.
What is petition?
Petition is under 6 rules for incorporation of B schedule property.
You filed suit in 2012.
Look,
but filed IA for 2022.
Look,
after 10 years.
Commencement of the trial, I was commenced last year also. Prior commencement of the trial, I filed that.
Who is the contesting party?
In that we have filed not. That we have filed not. I think that it is a government act.
Okay, well, interested party.
Yes. So we get to this.
Okay, they said there were not a national parties in the CRP.
No, not a.
Not mentioned as a national party. National parties. Government is necessary party.
Yeah, as per their claim, but as per my claim, it is a private property. With regard to a scheduled property, they are claiming that they are one of the
There are B and B scheduled properties.
Lord, A scheduled property, Lord, in the A scheduled property, there is a government school. And the government school is running the.
Scheduled properties, playground.
No, the B scheduled property is totally private property. It is a building.
Open, huh? It is not building.
There is a dispute in the schedule. Open for that, we need to get it.
AGP for arbitration. 6-10. Post after 3 weeks. No, sir, no anti-war special. Already pending 2022 hours.
Item number 57, B. Dayasagar, A. Gopal.
That's not any position as on the date of the filing of the already we have established our title and as well as the position by obtaining the orders in 1312 of 2012. That was filed along with the perpetual injunction suit. That was that I would like to bring the lordship page number 40 minutes.
Last case, he wants to withdraw the CRP.
So withdraw my CRP with respect to the declaration of title, declaration of the title. As I am dispossessed during pendency of the suit, we lordship, we prayed lordship to made findings on recovery of the possession. Then only we are accepting for the IA. We are not proceeding on the declaration of it. This is incidental to the main title. This is incidental to establish the title in perpetual injunction. But is not necessary, as I always sought for the permanent injunction based on the documents as well as the possession. As I was dispossessed during the pendency of the suit, that is the reason we filed two IS made. One is 195 of 2014. As we dispossessed in 2014 itself. We are as on the date of the filing of the suit, and also in the IA, we are in possession. That was the last kindly go through the.
Suit for injunction.
Yes, sir. Next time. Yes, pushing next point. What is the trailer plane? Show your plane copy, sir.
Yes. Yes, I have the plain copy 104 and 1.
Your prayer is?
My prayer is with respect to the reason to pass a judgment and a decree in favor of the plaintiffs against the defendants as follows. That is, A, to grant a decree for permanent injunction restraining the defendants and their subordinate agents and so on so, claiming to from interfering with the peaceful possession and enjoyment of the suit of the plaintiff number 1 for the suit schedule property. That is for permanent injunction. I start.
That is the main prayer. That is the only prayer of your suit.
Yes,
prayer?
Yes, exactly. In
that is suit of 2012.
Yes, ma'am, that is 2012. At the same time, I also filed IA number 1312. Yes, ma'am. That is page number 39. Ma'am. Page number 39, there was a typographical error on the mentioning causes on the hospital 1312 of 2014. That was erroneously typed by the judicial lawyer at the time. And this is actually in fact 2012. That is 2000. On the second, on the page number 40, lordship may kindly go through.
petition filed on 27/12/2012. I filed that IA on 27/12/2012. Petition number on 27/12/2012. That as on the date of the filing of the suit, along with the plaint, I filed this IML. As there was an urgent notice was ordered, and that suit is coming for hearing from time to time. During the pendency of the suit in 2014 itself, Miller, they disposed from my possession. I already constructed compound wall and I am in exclusive physical possession as well as the supported by the documents. My suit is from permanent injunction. By the time I rightly filed for permanent injunction based on my title as well as physical possession. During the pendency of the 2014 itself, they trespassed into the suit property and disposed of me. This was that I filed for a temporary mandatory injunction to remove the constructions to provide the suit property that was allowed by the trial court in the 2014 itself, and also to remove the construction super mode and not to make further constructions in IA number 196 of 2014 also granted. It is also in my favor. By the time of the same day, the Lordship has passed orders in 1312 of 2012, granting temporary injunction till disposal of the suit. I read the contents of the order findings of
What is the present IA, sir? What is the present IA?
Yes, ma'am. Based on the subsequent, which disposes me from the suit schedule property, I filed to incorporate amendment petition. I incorporating the subsequent events.
Separate suits are where the question of filing is.
Yes, that is my appointment. That is the case. That is second principles of law. Then once between the same parties, if it is agitated from the same parties and on the same cause of action.
Once you are accepting that there are not question of property, where the question of continuing the injunction suit.
This order has been passed in the year 2014 itself. The injunction, which is my land plus statement, which is that was not done so when it was disposed.
Immediately the time prepared CMS. That CMS has been got dismissed in 2018 itself. I was created in the second edition district judge.
Then you are property.
My title and
yes, sir. Then you are question the property. Take by application for the post production or the discipline order for the
that can be agitated by me. EP by filing. No, my position has been established. The court has appeared.
Pilot petition for discipline orders, sir, not by the amendment of prayer in the suit.
That is the amendment of the prayer only.
No, how can you file amendment in the rejection suit for the declaration of the title?
Yes, my as a disposed.
Then
how it is incidental, the title to establish incidental injection is incidental.
Same argued the same point.
Based on that, we made the last occasion. We are not pressing for the declaration of the title, but we are pressing for the recovery of the possession.
Injection suit means you are on the position of the property.
Yes, that was given in
violation of the orders, you have to file separate.
Yes. If at all I have to file, then I am forced to file any subsequent.
Not forced to file, sir. You have to file.
Then we automatically in tax principle multiple proceedings. In that circumstances, Supreme Court held that it is liable to be amended.
So next up suit can be changed. Next up, what is the suit for the injection? Now we want declaration suit.
Submission. This is in addition to my earlier permanent injection. I am not substituted. It is not substituted.
Injection suit means you are a position of the property.
Yes.
Now again you ask for recovery of what is the contrary suit price? How can
yes, melody. As I am disposed during pendency of the suit.
File a petition for violation of orders, sir. Visible orders of the court below. What it has a CPC.
A clear provision is there.
That at the time of final adjudication of the permanent injection.
No.
Subsequent to the permanent injection only, I am entitled.
Rightly orders passed by the time.
The application filed was dismissed only based on the belated stage.
Based on the millet stay.
The cause for petition respondent post after 4 weeks. The cause for orders.
Millet on submission millet.
Yes, sir.
In this matter millet, I am filing the judgments.
Then I'll hear you. After 4 weeks, I will hear it. After the
On the day.
Item number 58.
Must have.
Vijay Shankar Sharma.
There is a respondent counsel in this matter. Also, the respondent counsel is specified.
Your Lordship, I'm appearing for the petitioner.
Yes, madam.
Your Lordship, if my learned counsel is ready for arguments, the matter may be passed over.
1 minute, what
1 week of time, the respondent counsel is personal income. 1 week of time. 1 week.
February. You want to quote on February 17th. As per the respondent seeks temp post after 3 weeks.
Your Lordship,
I'm granting individual orders, madam. Orders. Yes, madam.
Your Lordship, may I request the matter be posted in the first week of December? Senior is out of station.
4 weeks then, post after 4 weeks. Fight for.
Interim master extended till then.
Until orders, madam. Not till then. Until orders are gone, extended. Motion
Much
fight for.
obliged.
A. Prabhakar Rao, A. Venkatesh.
Yes, sir. Petitioner. What is the reason? You can argue the matter. What is highest, sir?
The amendment which is final at the late stage. After amendment, the order 6 rule 17 empowers the court to amend it. It is necessary at any stage of the procedure. Even up to Supreme Court, it should be under. To put it up 2 days.
Actually, last second I post for dismissal in this matter. Post for petition seeks temp post after 2 weeks.
Item number 60. Civil Srinivas.
Petitioner's minutes.
Yes, sir.
Rejection of plain petition is dismissed by the defendant. There is an arbitration clause out of a development agreement. Therefore, you have to go for arbitration, not a civil suit there. And I find my rejection of claim. That is dismissed. Development agreement is at page 38. I'll read out the arbitration clause first.
Is it registered document, sir? Registered document.
Yes, it's a registered document. Development agreement from general power of attorney. 29 to 38. 38 is the operative portion. May I read minutes? 35. Any dispute arising between the parties in relation to any matters arising out of the instant agreement or otherwise shall be settled through arbitration, which shall be governed by the provisions of Arbitration and Conciliation Act. Now, as your lordships are aware that an arbitration agreement itself, this clause itself is a separate agreement. Once mentioned in any agreement, an arbitration clause is to be treated as an independent arbitration agreement. Therefore, the parties are supposed to go for arbitration. Instead,
who is the respondent, sir? No, evidence from the respondent. Product of person. And of course, for petition, provided take court personal respondents, direct law service. So this is the 310. 310, evidence notice. What happened? Rapid law service, sir.
I'll verify minutes.
You're not right.
I'll verify minutes. When we have it after 2 weeks, I'll verify.
First, but the 310, law service, post after 3 weeks.
More less minutes.
Item number 61 and 62. A. Prabhakar Reddy, R.R. Kalyan.
The last question argue the matter, both of you are requested. What is matter, Kalyan?
Obligation is filed. summoning of the classroom to give evidence with regard to ROR proceeding. Second application is telling the proceedings by the declaration of the failure was done by the classroom under section 5A. I think that there is a booking stamp and it is a registrable document and it cannot be taken in. However, once section 5A proceedings are allowed, it is equivalent to registration of the. It is only a subject of section 47 of the Indian Registration Act. Okay. It states that the document doesn't come into force.
Okay, now they say their suit. Post for petition seeks time. Post after 2 weeks. Yes, sir. You are in action at till then. Who matters?
Item number 63, PV Banu Prakash, GU Asset Assess.
What is the matter? Already 6 time. Total correspondence. Post after 4 weeks.
I'm for the respondent to the lordships. I'm here on.
I know, sir.
Respondent.
Not mentioned. Okay, constant. The 6 and post after 4 weeks.
Obliged lordships.
Item number 64, E. Suryanarayana.
Preparing for respondents, I filed Waka today. Okay, in my 2 weeks time, without my name may be printed. And so is as well.
Post response. 6 time 12 quarters. Post after 3 weeks. Which is related to the remark.
And so is as well.
Leave script, sir. And all. Yes. 3 weeks, madam. Makes no difference.
Item number 65, R. Vishal, visiting house.
Against the arbitrage TV. So the cat from the data. It's when this arbitration is award only against the one suit please send the sleepy to the second respondent in the present case. Yes, 71 days.
Well, common right. Only one respondent here. Appeal 6 months. Current decree order. What is the order, sir? What is the order?
Page number 6 millet. 1/3 share of the salary was attached millet. An amount of rupees 30,57,000. 19 rupees.
The office subordinate.
The office subordinate. Since from 1 month period, I am unable to claim the salary bill. As the sir has been completed.
No, sir, you can claim.
Please see that as per my share, it comes only the 2 lakhs to be paid.
There is no share, sir. As surety you have to pay. The degree holder can have right to claim any month. There is no shares for the surety.
The sureties are taken already this second respondent. Against them, there is no such award and order was being passed.
So what is the amount of 1/3 salary, sir? What is salary? What is the amount of 1/3? You can get the 40,000.
It's for 2 lakhs. 1 month I'm unable to claim the salary.
You can claim, sir. You directly the amount you can claim. Good back. You want the entire salary, that's why you're not paying the remaining salary.
Pay the money. They refer to the mediation.
And I'll post after 2 weeks or 3 weeks. But you're not receiving the amount. What is that? Who have prevented you to receive the salary, sir?
Yes, if I receive the same salary, attach it to the order of the court minute.
Then that's definitely. As per orders only, they deduct the amount and remaining amount they have give you. You don't want salary. Without salary, you can survive. Survive for 3 or 4 weeks. Last second month, orders passed in 2022. When was it? January 2020? January 2020.
There is no clear notice in the what was passed in the current year. There are the state of Adilabad. They have been issued the paper publication here. I have not noticed it here.
That is bad. Merits of the case, sir. No concern.
I agree.
File petition before they.
They may be granted at least within present situation.
Well, not receiving salaries of 11 months.
To receive the salary on 7. But will I, if I am entitled to pay, if it decided the main case, I get a present situation.
Total, how many members of the security? 5.
Sir, mechanics in the page number 7 headed. From 2 to 7, 6 members are the sureties in this case. All are the government employees. And I am the respondent number 6 in the case.
Yes, sir. 2 lakhs means amount same, sir. 20,000 per month you are deducting. Now 10 months over. Same amount 2 lakhs. You are not issuing amounts. Last 10 months you are not.
22 days 2 lakhs only, but more than that I cannot pay.
Okay. Record of petition. What about respond? Notice respondent, sir? Already happened. Okay. Someone filed. Respond number 1 filed Wakala.
Rest of them has not filed Wakala. But I have served as per the orders.
You are Vishal.
I myself Vishal Rai.
Gulugul Srinivas filed Wakala for respondent number 1. Gulugul Srinivas, state funds. Also, receive Passover afternoon. Passing in the majority and the Wakala. Wait.
Keep them.
Yes.
The infraction.
Okay.
Main switch is disposed.
Of the president. May should dispose of this. Yes, no color for Yes, sir.
Assault matters item number 26, now as investor.
No color bloods post after 4 weeks.
Item number 65. Arbitration. Yes.
Yes. Yes, sir. Yes, sir. 130. Date of the petitioner. None of the respondent. Of the respondent. There is a STR postal in EP number 290 of 2022 in 2022 in arbitration number 7 of 2018. Rated. What is the last data, sir? 2023. That is announcement data. Yes. Proceedings. Is the announcement data? This is the proceedings.
Yes. Page number 6.
Page number 6, huh? Rated 2023. How will you condition that? It is rated to 5 rupees 2 lakhs. The account of EP number 2022. Still 4 weeks from the couple further. 4 weeks. Asking, huh?
I am unable to claim the salary since 1 year. Because this is the 11th month. Even I have celebrated with Dasara without the salary.
Oh, the Campbell have to survey. Huh? Not of Dasara. Before that, the number of festivals over. Not of Dasara, sir. From January, number of festivals are Hindus. Huh? 6 weeks. Okay. In case, post of pioneering after 6 weeks. Yes.
I got it.
Come tomorrow, sir. No urgency. Wait for 11 months.
Continuation item number 66. Legal oil by P. Ashok Kumar.
Your Lordship, I am for respondents. Kindly, I shall file counter. Kindly 4 weeks time I will granted, Your Honor.
Sir, you want to file counters in IA?
Yes, Your Honor.
Kindly senior is coming is on the way. Hospital.
I shall file counter in the case. I am for respondents, Your Honor. Your Lordship. Kindly 4 weeks time is granted.
What is order? What is impeded order?
Both concurrent orders, status quo orders, Your Lordship.
Where the orders are trial court, sir?
Lordship.
Trial court's order. Page number.
So file I'm not with me, Your Lordship.
The cost both sides. Post after 2 weeks.
Lordship.
Item number 67, N. Mohan Krishna, West Wing of Study.
Both sides. Post after 4 weeks.
Item number 68, M. Satish Reddy, Sandeep Kumar.
Yes, sir.
I have further notice for the council.
R1 to R4. Climates.
David. These are by the proof of service in the finding.
Okay. Building was collapsed. Spot number 1 to 4.
The lordship is ordered to serve notice on council. The last edition.
Okay, I'll interview.
Yes, sir. Sir, by finally. Already there. Documents are permitted to withdraw.
No, sir. In my order, no permissions. Okay. Hello, sir. Okay, 3110. Sir. IA number 2. Sir. Another number 1, 2, 4. Request of petitioner. Further. Relapse source is condoned. Main case admit. Postal finding after 8 weeks. Maintenance service court below.
Item number 69, P. Srinivas.
Post after 4 weeks.
Item number 70, G. Rajkumar.
What are the notes to respondents, madam? Sir, or not? Question number is there. Saruda returned, madam. What is it? Sarud? No, Sarud, madam. What is that? Service of notice? Nine, 10. First, also notice on the respondents. IA number 2. Take up the petitioner. That's wrong to this control. In case admit post of finding after 8 weeks.
Item number 71, CH Srinivas, V. Venkatrareddy.
Yes, sir, no problem. Is it? Are you ready to stand? Yes, Venkatrareddy, no problem. Are we?
Client strategy of the system and finding a triangle having.
There are notes of response or not, sir? No notes response. Already find one call. Okay, Venkatrareddy is there.
He was working in. He was working in the rest of the data. Stake. Is famous for his for making area practice.
Only 400, yeah? No MC, you are working. Private employee.
No, no.
Call it on private employee. Not find any MC. There is no stay. Take off a petitioner. One of the respondent. Look for orders of 1 week. After 1 week, sir, for orders. Right on?
Both are received and only for this case, they are trying to.
I was posted for next date of hearing, sir. What is the date of next date of hearing? I posted on 14/11, sir.
Item number 72, M. Balraj.
This is voice message. Yeah. Post after 2 weeks.
Item number 78, Dekhanreddy, Kasireddy, TSHC Murthy.
Yes, he is ready. Yes. That's what the case. Madam, you are petitioner. Then wait. Then wait. Petition counsel is here. Then wait. Yes, sir.
In this case, you are asking. Respondent advertised by the application in last week for resolution of marriage. Before the district court Bandra you were 84
2020.
Yes, sir. 68 of 2020 and file of this resolution. And there are total 4 cases in last week. The file filed the restriction of controllers at Almoham. And another application filed by the wife later, what happened to my respondent has filed an application. They have filed the another transfer of your action before this answer to transfer the restriction of categorized application before the district marketing. The same is being transferred because we were not receiving any notice. The Supreme Court has given a direction to serve the notice in the lower court advocate. Accordingly, they have served the notice. Actually, we are receiving a Kanmakondi of some village, but they did not send any notice to that place. And they were sending notices to Hyderabad where we were residing at that time after the marriage. And anyway, we were asking, later we have filed an application before that transfer of your asking for modification of the orders, which is pending your asking regarding that transfer application is concerned. Now, this application concern you are asking, the respondent is working in railway department and is getting a 70,000 rupees. And so that you are asking, this application may, because she is driving, they are driving a small, you are asking, 3 years old. And the petitioner's mother, nobody you are asking, only mother is there. It is very difficult for us to come out with the market report and data carrying.
Better to I post this matter than that matter, sir. It is better. Because otherwise, again.
Yes. That is IA, article you mentioned, IA 1/23, IA 1/23, 2/23, and another petition is 3/23.
Post this matter. Post this matter. Transfer matter. Pending for this court. This is to post this matter. IA number 1/23, 2/23, in CMP number.
Item number 7
This is to transfer the HMOP file from city civil cost to Martin lot. And for the wife lot. Actually, in the year 2020, the wife has left the society of the husband and went to his parental house lot. She is having 2 minor children. One is 4 years old and other is 7 years old. They are residing with the mother only. They are residing with the parents of mother on the grace of father. She is not an, she is an unemployed. She's living with her parents only. She has filed this DVC before this monthly court law, which is pending. And meanwhile, a maintenance case is also filed in the
Yes, sir. The clerk or taken.
The thing is, both the DVC and maintenance case are pending in the monthly court lot. And after, like from the 3 years, there has never been a time when this respondent has ever met this person or paying for any maintenance lot. It is very difficult for the petitioner to travel all the way from Manthini to Hyderabad. It's around 300 kilometers, carrying all the 2 minor children, who is living on the grace of her parents without any income or anything to travel all the way to Hyderabad to attend all the procedures.
Sir, in Manthani, there is any family court is there? In Manthani?
No, city, single civil judge.
You mentioned a family court at Manthani?
No.
In para number 11?
Para number 1. Para number 2 million.
Para number 11, last 2 lines. Mention a family court Manthani.
The second para.
What is the prayer in verse then? Yes, Judge family court Manthani. Where is the family court in Manthani, sir?
No, senior civil judge at Manthani.
Docket shows that family court Manthani. The prayer.
The prayer of the, it is mentioned as senior civil judge.
Okay.
In the prayer
is mentioned as a
senior civil judge only, but
senior civil judge Manthani. That's a cut and paste problem. Okay.
Respondent Miller, present case status Miller, on 6/10/2023 is posted for the arguments. After again 16/10/2023 for arguments Miller. Next this month Miller 16/11 also for arguments Miller. This is the only pending only for arguments Miller. Total.
The case is pending for June only. This court has passed a stay order in the June only.
The present petitioner or counsel It never appears before the court from the filing of the divorce. We don't know there is stay, court don't know there is stay. At that time, at this time, case transfer.
I myself did not clients in our that case as well. I have appeared before this court and I have also filed this memo dated 14/6/2023 stating that there is a case pending and until then there was no stay issued. After that, we tried to send this notice 2 to 3 times, which was returned as a case was closed. After that, on the instructions of this court, I have filed this memo on WhatsApp to the counsel of the respondent. After that, they have appeared. Meanwhile, the stay was already granted in the June, and the proceeding, there was 1 or 2 proceedings after which, even after stay. However, I have already given my notice on 14/6/2023, which was already accepted by the respondent counsel, and it was filed in the court.
So, what is stage of the?
So, they are saying in the arguments, but the thing is, the chief was filed.
For arguments,
it is for the counsel. That is what now the cases has been came to for arguments.
That's why I'm asking.
Yes, that is not the case was stayed in the June only, but after June, after furnishing of this memo saying that the case is filed, that proceedings was continued. Say for the 2 proceedings, I was not available to talk because however in
2023, respondent defendant evidence.
Yes. It was stayed in the June. I have already submitted this memo as.
Then how can I will call for the report from the officer, the threatening officer? This was stayed in the month of June.
Yes.
When was this copy? Sir?
Maybe serve the
copy. The thing is, first I have filed this memo. Let me. First, I have filed this memo saying that the case was filed, which is pending for adjudication in High Court. That was already transferred to the family court. After which a stay was granted. The stay was served to respondent, which was never received. After which I have served to the counsel of respondent through WhatsApp, which was received. After which they have filed this counter in this court.
This copy marked to Judge Family Court, Civil Court, Hyderabad, and dispatched on this from this court on 16 June. Then how can I proceed further? The civil judge. Then I will call for the court from the concerned officer, proceeding officer. You are not ready with evidence. You are not completed with evidence.
No, I just given my chief examination. Chief examination was done. I filed my counter. Chief examination was done. That's it. After which there was this stay proceedings, transfer was filed, and it was communicated. I have given this.
Court also communicated, sir.
Yes, my lord.
Copy to the market to the Judge Family Court, Civil Court, Hyderabad.
Yes.
Dispatched on
notice. I tried to send it
6. Yes, sir. So, advance 7. How can they proceed, sir?
We don't know about the order, Millard. We don't know about the proceedings. They never come to the court, Millard.
Yes.
Even counsel not come.
Concern stay order is granted. It has to be straight.
We don't know about the file or not.
It was already communicated, Millard. It was communicated both to the respondent counsel and the court as well.
Also communicated by this court also.
Yes,
the court. The matter was posted for arguments on 16/2010 and 16/10/2010.
Item number 75. K. Puchpa.
Yes, again, both of you. What happened? You want to compromise the matter?
In this matter, we tried for
negotiations. Okay, so what is saying? Huh?
We tried for negotiation first, but
Yes, argue the matter then.
transfer to the Huzurabad from the football.
Because of the taxes.
Having DVC and insurance.
Pending.
Pending.
pending before Huzurabad.
Here goes, yes. Ask it aloud. Let's ask. Recommendedly opposed by the correspondent. Huh?
My condition may be recorded.
Yes, sir, yes, sir. You're not going to the counter.
No.
Not necessary. Okay. No course for the transfer the matter. Yes, transfer allowed. Yes.
Item number 76. E. Sudan, appointing person.
Vector representative. Petition is filed seeking transfer of the MC from Family Court Hyderabad to the Family Court of Secunderabad, Madras, wherein restitution of conjugal rights.
Hyderabad to Secunderabad.
Hyderabad to Secunderabad. Yes. Because there in Secunderabad court, divorce OP, restitution of conjugal rights OP, as well as GWOP. Three
filed by?
Filed by, divorce is filed by her, divorce is filed by me, restitution is filed by her, and GWOP is filed by her. So that is, they all are pending before the.
Okay, two cases filed by the respondent, one case filed by the petitioner, and before this, Secunderabad court. What about this present case?
Present case is under section 125 of CRPC seeking maintenance by the respondent herein, which is pending before the Hyderabad court. Which follows, because common trial can be led there in the Secunderabad court, the proceedings can be transferred there because already she is seeking maintenance here in the family court of Secunderabad, where all these three proceedings are pending. She has filed IA there also for seeking maintenance. Besides this, in a DBC proceedings, my lords, under Domestic Violence Act, she files DBC proceedings and IAs for maintenance, wherein she is getting maintenance per month to the tune of 35,000, and she is not getting evidence since about 10 months. This Honorable Family Court is also, DBC Court is also observing in its docket order. Now, my lord, she resides at Bagambarpet, Secunderabad Court, or the Hyderabad Court, both are at equal distance to her. Apart from that, your lordship, because she is seeking maintenance application before the Family Court of Secunderabad, which is pending as of today. Her maintenance proceedings before this court can be transferred to that court, wherein altogether once and for all, it can be decided how much maintenance she is entitled for. Your lordship may see the order, petition filed by her at page number 141. Page 141. In FCOP 231 of 2019, she filed this IA. Relevant portion at page 149, prayer. She seeks the maintenance of 2 lakhs per month in the divorce, OP and restitution of conjugal rights in Secunderabad. This she is asking. Now before the MC court, which is before your lordship for challenge and at page number 7. Page number 7, she is seeking a maintenance under section 125. 125 your lordship knows a monthly maintenance can be given to her even if the main case itself is disposed of. So there at page number 13. Here also she is seeking 2 lakhs. There she is seeking 2 lakhs, here she is seeking 2 lakhs, and DVC case which she has filed against me, in that she is already getting certified. I will show that order also to your lordship. DVC petition is at page number 65. One order is at page number 109, and another one starts at page 116. Relevant portion your lordships at page 115. Page, in fact,
114, last paragraph.
last paragraph, 25,000 per month. Then another order she gets at page 116. Miscellaneous petition 745, relevant arise at page 122. 10,000.
Order 8th November 2020. What about this order? Addition to the 25,000, 10,000 again.
Yes, besides that, because she has asked for household as well. For household rent, this is 122, para number 8.
Only for rent.
Rent.
So she's already getting this benefit of this interim maintenances from me. Now she is not leading evidence at all in the DVC court, which is not under challenge before your lordship. She is not leading evidence there at all because she is enjoying this money since many years. Now, because she is getting this money since January, as per section 12(5) of the DVC Act, it says within 60 days dispose of the case itself. Since 10 months, she is not leading evidence. Honorable trial court records it very clearly that case would be dismissed for non-prosecution. Some or the other miscellaneous petitions she files and gets the case delayed. Now she is getting benefit of this maintenance. Now she files MC seeking 2 lakhs maintenance. She files IG in the family court where already divorce OP and this restitution of conjugal rights is pending. Therefore, your lordships, kindly appreciate this. If there would be no harm in proceedings are transferred to the family court where once and for all it would be decided how much amount she is entitled, if at all she is entitled under maintenance. Yes. And because she decides that a Bagambar paid, there wouldn't be any, both places would be at equidistance to her, even Secunderabad and Hyderabad, because I am an employee and children are also with me. DVC court, family court in GWOPIA has granted interim maintenance of children also to me. I am taking care of my old mother, children, and myself. And besides that, I have to pay her maintenance for no fault of mine because she is not leading evidence in DVC court. Now she files this all IS in all the courts wherever she has, so that she could get benefit of maintenances from me.
Yes, sir.
Therefore, your lordship, and in fact, one more small submission. When she has filed a restitution conjugal suit in Hyderabad court, this honorable court has transferred it in the year 2022 to the family court of Secunderabad, page number 37. Page 39, relevant para is at para 5, page 39. Para 5. Page 39, para 5. Maybe.
Yes.
Accordingly, the transfer of civil business is allowed and FCOB number is withdrawn from file of additional family court, city civil court and transferred to the file of family court, Secunderabad for trial and disposal in accordance with. Is driving the proceedings. Same submission is there. The court is directed to dispose of all these proceedings expeditiously. That is pending because there it is yet to come for trial in family court. Here, this Hyderabad court where she has filed application number 125 is pending because your lordship knows it under 125, assuming the trial court orders in her favor, assuming for movement without considering, only she can get monthly maintenance, final disposal also. This anyway she has filed an application in the family court at page number 141. That can be decided there also in the family court where common trial is to be. Yes, sir. My respectful submission is kindly allow my petition and transfer the proceedings from Hyderabad family court to Secunderabad court where all the proceedings are pending.
Yes, madam.
First point is there are no cases pending before principal family court. The prayer clearly states that the petition is asking for the transfer of the case MC 807 to principal family court. My cases are pending between first additional family court. On 26th June itself, we were informed orally. On 28th, it can be transferred to first additional family court. I can give the equal status. That's permitted to see it. And coming to the point of maintenance case, sir, it is pending from 2019. I have been given the interim orders in 2021 June. 2 years have been left for them to find a counter and to give the income of sets and academic of salary for present. I was forced to direct the court was forced to direct the employer to produce a payslip. Till date, he did not produce anywhere that level. And the so-called what is telling about 705, which I tried before the Honorable Secunderabad Family Court, requesting for for maintenance, it is 705 of 2020. Today we are in 23, almost like happened 23, we are about to go 24. Till date, he didn't find his evidence. Coming to the point of DVC.
Madam, I know my concern. Overall, the transfer of your MC case to the.
It is no grounds, sir. It is absolutely jeopardizing interest. Whenever he is asked to.
You have filed petitions for 2 lakhs for the maintenance in the. Yes, 2 lakhs before the one court, 2 lakhs for another court. You want to.
I have already informed.
Well, okay, Emphasis. Clear both sides of the orders after 3 weeks. Till then. Yes, sir. Already filed counters. Where is the person filing requirements? Already filed counters.
Item number 7 is from K. Rajeshwar Rao. by Balmurali.
Yes.
This transfer petition is filed by HCOT. Divorce petition filed by the husband from Ranganahigh Court to December.
Yes, sir. Yes, sir. Stay here, sir. On the last section, also extended. There is continuation, sir. There is no limited stay. We'll cut it. First plus 6, to file a course after 2 weeks.
Item number 78, B. Ramulu, B. Amrutara, C. Hemant Kumar.
I have seen scheme.
This is the transfer
I have seen scheme.
Well, I think the law council is here. But represent that they may be appearing to on.
Last occasion they appeared for
because they are from accommodative.
This
I'm seeing this thing.
They are provision for them to appear to virtual mode. Local advocates also. Not for the limit of High Court advocates. They have limit of the local advocates.
Yes, it's a convenient for advocates. Anyway, for integrity. You have to present a transfer petition file. Speaking, they are seeking the prayer from transfer the OS civil suit.
All the demands granted by this court.
Last change regular, but only it is where the suit filed by them, the respondent filed in the year 2018 is pending. Where my vendors were filed CRP before this honorable court, seeking a prayer loan. Said that here as early as possible within a period of 4 weeks. That was ordered in the year 2019 itself. Where we have to seek a relief to stay up all further proceedings, which the suit is pending before the district court. But instead of asking that suit, we asked our own suit for stay, because where we are having an injunction in our favor due to the technicalities that injunction was that suit was returned and resubmitted before the senior civil judge court. The same subject property between the same parties within the premises of the same court, the commodity court itself. But the limited prayer before the honorable court is where the suit 1 of 2023 is pending before the senior civil judge court has to be transferred to the principal district judge on the ground that if the contradictory orders passed by both the courts, it may be difficult to the parties. That is the reason. But we are before this honorable court. But voluntarily they are avoiding to appear before this honorable court. Though the other parties were receiving the notices, they won't choose to appear before this honorable
They
court.
filed both are filed vocals, sir. Respondent 1 and 2.
Well, at last occasion they were not present. But today, last occasion, the council who appeared on behalf of the second respondent is also today is not here.
The last occasion they asked for time for filing counter.
Yes, but your lordship granted time for filing counter itself today posted for it.
Here comes for petition under the respondents. Both orders after 2 weeks.
Item number 79, B. Srikanth.
The application is filed, Millard, from transfer from LRA.
Okay.
Transfer from LB Nagar court to Karimnagar, Millard. The notice was
Karimnagar to transferred by this court.
earlier it was transferred, Millard, but the proceedings are urgent on account of non-production of documents by the revenue officials. And this is a matter arising under Land Reforms Tribunal, Millard. But I am laying upon one judgment, Millard, there is no res judicata is applicable because it is not a suit, it's not deciding any issue.
Order the respondents. Order.
Notice was served, Millard, by way of substitute service.
Take out the substitute of service. Subsequently, we have published it in the local newspapers of the jurisdiction pertaining to Malakpet and as well as.
Where is the memo? Malakpet, not Malakpet, sir. They are residing at resident of Karimnagar or Malakpet, sir.
Yeah, the correspondent number 345
But the 4 is residing at Saidabad. 5 is Santosh Nagar, 6 is Ramchandrapur. Therefore, we are published in two newspapers. One is at this Malakpet area, one is at Sangareddy area.
Right, this day,
Yes.
13 level. 13 10. 30 10.
30 10, please.
Well, the contesting party, my lord, second respondent is not, notice was served on him, my lord.
October. I think that's not already this code.
Yes, sir. At the instance of the second respondent, the transfer application was filed, and at that time, we have not appeared because and subsequently.
For reverse the matter.
Yes, sir. You'll also kindly appreciate, there are two suits are pending filed by second respondent. Partition suits are pending in Karimnagar. The record pertains to the land reforms tribunal is pending before.
2000, when was orders passed by this court?
Well, that is 2014.
2014, after 9 years, you find again.
Even you will actually can say page 31, Millard, page 32, Millard, the proceeding sheet, Millard, I filed, Millard, but 32. Every date, Millard, this matter is urgent.
I direct them to pass within short
Millard, we already submitted our written arguments, Millard. Millard, your lordship, I leave it to your lordship, Millard. Millard, if it is because Millard, the records has to be Millard in
old matter 2014. Matter transferred to the Rangareddy court. Will direct them to dispose of the matter within 3 months or 2 months.
Millard, I appreciate. Millard, your lordship, I kindly appreciate, Millard. Millard, it is a matter of 2007. Appeal is 2007. 2014. Now 2007 we filed in Karimnagar.
2014 they were transferred to the Rangareddy court.
Yes, Rangareddy.
23 of filed petition transfer again for the Rangareddy to Karimnagar.
Now records in Karimnagar, Millard. The lordship, the revenue officials are Millard the holding the records.
The court has to take notice, sir.
Every date is Millard urgent.
Then I fix some time limit, sir. That is better. Unnecessary. Again, waiting for notice and again transfer to the.
Millard, may I submit, Millard? Your lordship may fix any date, Millard. Millard, your lordship may also direct the Millard, the revenue official produce the records before the appellate court, Millard. That is a first respondent.
And that is the district court has taken into account, not by this court, sir. They have to give notice to the authorities.
Your lordship may direct the district court, Millard. I am not saying.
They have to take steps, all steps.
Now, your lordship mentioned, Millard, mentioned the same.
Today, we'll take it about this 1 month, they have not done anything. Elections are there up to December 15.
Yes, Millard, I know, Millard.
Department, how can we say that? That's it.
I leave it to your lordship, Millard. The lordship may pass appropriate orders, Millard. Millard directing the appellate court, Millard, to pass expeditiously within 2 months, Millard.
3 months, sir.
Yes, Millard. Yes, Millard.
Dispose of red court bill to dispose of the LRA number 2014 on the court bill within 3 months from there is become started. As part of the last one. It is there. Yes, sir. Dispose of.
It is the adjourned item number 81 and 82. B. Ravikumar Reddy.
Yes, sir. You want? Also, it is the covered issue because of the current because of course after 4 weeks. As per the
Item number 83. B. Gita.
yes, sir.
This matter notice is served and sources on because filed last time. How are you appearing?
Right hand over to Madhuravani. Current plaintiff. What is the case?
My case is suit is filed for declaration of title and possession allowed. Suit was allowed on that I filed appeal. And my appeal is and that I filed. The lordship heard the matter at length and speaks to that maintenance directed to maintain status quo.
Today you are not ready for the main case. Admission, sir. Once for the plan. 6 10. Post after 4 weeks. Assessment of the action till then.
Item number 84, 3 beneficiary of the Srinath Reddy.
May please losses, but I am representing the council on record.
Yes,
this is an application to condone the delay representation. The petitioner is aged about 75 years. Suffered during the period of COVID. The matter was returned. But the party could not be able to submit the records. Therefore, the delay has occurred. It may be controlled and posted for admission. The respondent is the Secretary County's Council.
Yes, sir. Sir, paper served the standing council, sir.
We already served it. Otherwise, we will serve it. I will serve it.
Okay. Yes, media procedure. Delay representation.
Delay representation.
Cost of petitioner response. Control. Post for admission after 3 weeks. Yes, sir. Some papers will also.
Yes, I will serve it. Next week, your last is so convenient.
3 weeks. 3 weeks.
2 weeks, your last is kindly say.
Okay, 2 weeks. Okay. Yes, sir.
Okay.
Item number 85, by Ramaram in
What the counter, sir? Admission. Huh? Electoral board said agenda matter last occasion. Huh? What matter? Yes, 11 also. Then post reference 6 times. Post after 3 weeks. Meantime, reference are added to serve the copies to the learning course for the respondent one. Huh? And 310, and because of both sides, 4 weeks. With the filing counter, sir. Yes, sir. Counter and fines, okay. First for both sides, 6 times. Post for 3 weeks. 12 papers, yes.
Item number 86, is Praveen Kumar K. Mohan. Present last application is on file.
Appearing for the respondent. In fact, I filed a vacate stay. Interim order is on the condition to deposit 5 lakhs.
5 lakhs. I think 3 times I reply same thing. Even half of the amount.
In fact, money suit 50% of the total.
What is the
Half of the amount, let them deposit that.
Wait 1 minute, sir. Sir.
There's no signature.
Everything they can suffer with dengue. That's why they want time, sir.
Sir, they have been, in fact, I am saying to make the stay absolute by asking them to deposit 50% and I may be permitted to withdraw. I am not asking to vacate the stay. So where is the question of the, in fact, I am arguing on their behalf.
telling them, you deposit 12 lakhs and I will withdraw the same, let the stay be made absolute.
Sir, actual outstanding amount is 8 lakhs.
Before now, no, your lordship would see the valuation of the appeal. It's 24 lakhs.
Including interest, is it?
24 lakhs. In fact, the only dispute is in the written statement, they said 9 lakhs cash they paid, for which there is no receipt. In fact, once you say you paid cash, the burden is shifted on them to prove how they paid. That payment was not proved. Now, that's the only amount which is outstanding.
Yes.
So, in a money decree, normally in European countries, if you have to fight a money suit, you have to deposit the amount so that frivolous contest will not be there. Now, here I am only asking in a second appeal, let the judgment debtor or the appellant pay 50% and obtain the sale.
Yes. Next week, last 2 times, 3 times, the same paper. How's for the respondent? Huh?
I am for the respondent.
Yes, sir. 23/9/69. Sorry.
They have just taking time for reply.
17/10 also.
Required.
Motion today. Last 3 times, madam. Both time today.
Your lordship, I am making a fair submission. I am not asking for any adverse order to be passed. I am saying let the stay be made absolute. Only they may be directed to deposit.
Both are the respondent. Only. Okay, cause for the appellant, please time post out 1 week.
Final email.
There is a grant only for 5 lakhs, 5 years. Post out 1 week.
Item number 8 is K. Gopal.
Personal permitted, what happened? Personal, madam? Or not? Not for service. So that's 610. Post after 4 weeks.
Item number 88, B. Kartik Navin.
Post per
1 to 3.
1 to 3. Post after 3 weeks. Madam, sir, क्या question ज़्यादा sir?
Item number 18 is K. Jagdishwar Reddy.
Yes. Same plan, 3 times same plan. Then cause appellant found that sole respondent expired and short time to bring a requirement. That is a illness. Same recommendation. Cause for appellant 6 for the time to bring a respondent. Post after 4 weeks.
Item number 19, Avishra Pujari B. Rohit, KSG Kumar.
These were appellants. But for respondents were also. Post after 4 weeks. This is the direct post is made alarm. Second appeal number
271.
2/7/2023.
Item number 91, please, Sunil go, please, Srinivas.
The last occasion related to. No, sir, SPA number 1, 3, and 4. What happened? Concurrent finding.
Reverse, sir.
Have purchased property through register saying that they are claiming that they have purchased property from a unregistered sale.
Okay, appeal allowed. Post for the apparent 6 time. Post after 2 weeks. 3 weeks, Iva. Okay, post for 3 weeks. Yes.
Item number 92, L. Harish, legal partner, Vasidis.
Are we allowed to appear virtually, my lords? I'm appearing for respondents in this matter.
Yes, yes. Sir, use mic, sir, in the area.
Yes. The appellants are plaintiffs in the suit. Suit is filed for specific performance of agreement. Suit was dismissed. Plaintiffs carried it in first appeal. That was also been dismissed. In the present second appeal is being. The facts are like this one. An agreement of sale was admittedly executed on 5/5/2003, and on that day, an amount of ₹1,50,000 was placed. This is not a disputed fact. Since the original agreement of sale is being lost, therefore the party could not able to find this agreement of sale. So a token amount was paid on 30th March 2003. That is prior to agreement of sale, 5,000. Subsequently on 6/4/2003, 45,000 is being paid, and subsequent to the main agreement on 16/10/2003, 1 lakh is being paid. And as per the elements in the plate, balance amount is also being paid in the month of January 2004. Therefore, the entire sale consideration is being paid, and the parties could not come forward. Defendants 1 and 2 did not come forward to execute the sale deed. Therefore, the suit is being filed. So A1 and A2 they have disputed it, because the agreement of sale, the main agreement of sale dated 5/5/2003, which is reflecting payment of 1.5 lakhs, is admitted fact. Even D1 and D2 also saying that we have executed this agreement of sale, but we are disputing that we have received 5,000 on 30th March 2003 and another amount of ₹1 lakh on 16/10/2003. So these two are being marked as exhibit A1 and B2. And the attestors are also being examined as PW 3 and 4. In the cross examination, a specific addition was given to the witnesses that the signatures appearing are not belonging to D1 and D2. So therefore, subsequently on a petition, the disputed documents were referred to the handwriting expert. Handwriting expert has published his opinion stating that the disputed signatures and the admitted signatures or the specimen signatures of the D1 and D2, they appears to have been of same, So the signatures on A1 and A2 are said to be true. And the expert is also been examined as CW1 and his opinion is marked as exhibit X1. For a moment, the attestors who have been examined, I have filed the depositions also, page number. Page 17.
Yes, sir.
He is attested to the main agreement of sale dated 5/5/2003. But since this agreement of sale dated 5/5/2003 is not in dispute, therefore, the PW2 evidence, PW2 is the attested to the receipt
which is being made in a note dated 30th March 2003, in proof of payment of a total.
Sir, what are the trial court findings? Show me, sir. What is the payment and what is the finding?
Both the courts came to a conclusion that
Show me.
the plaintiffs stated that the document, the receipts have lost it along with the agreement of sale. If that is the case, how come Exhibit A2 you filed before the court? Exhibit A2 is with regard to 1 lakh. So that is how the lower court came to a conclusion that no, you are not entitled for specific performance. Since the substantive question of law is involved here, Section 10 of Specific Relief Act has been amended in the year 2018. The word may grant and the discretionary relief may grant. So the discretionary power vested in the court. That word may is substituted with the word shall. This amendment is carried out in Section 10 in the year from 2018 onwards. This amendment came into force. Now the question is whether the amendment acts as retrospectively or prospectively, because it is a pending.
Specifically, no, that's what one perspective or not as a perspective.
It is retrospectively applicable. There is judgment note. I will find that supply a copy.
There is specific mentioning about retrospective.
Yes, our own High Court two judges, Justice Rajshekar Reddy and Shamim Akhtar judgment is there. Hyderabad spot receipt. I'll supply a copy of it. That is one aspect. Second aspect is that when the parties admitted the agreement of sale dated 5/5. So therefore, I have discharged my verdict, plaintiff discharge. Though the parties, defendants, are disputing A1 and A2, but they are being proved. But the signatures appearing on these receipts, A1 and A2, belongs to D1 and D2. Then the burden shifted on to the defendants to show that this amount is not received towards part sale consideration.
Show me the findings. Show me the findings.
Discharge.
Show me the findings.
Page 20.
Yes, sir.
Page 20, paragraph 15 of the appellate court judgment.
First trial court, sir. First trial court.
No, sir. Page 36. Sir. In order to prove these issues, the entire burden lies on the plaintiffs, and the plaintiffs have to prove that the defendants have entered into an agreement of sale dated 5/5/2003, agreeing to sell the suit scheduled lands for sale consideration of ₹3,64,500, and they have received ₹1,50,000 on the date of agreement, and also received balance consideration of ₹2,14,000, and even after the receipt of the said amount, the defendants failed to execute the registered sale. Admittedly, plaintiffs not filed the alleged agreement dated 5/5/2003, stating that the same was lost while BW1 was traveling in RTC bus, and to that effect, he lodged a complaint, and the police issued a certificate to the effect that the said document is not registered. As per the evidence of BW1, the defendants are the owners and possessors of scheduled land total measuring per acre 6 quotas, and they offer to sell the same at the rate of ₹30 lakhs per acre, and total sale consideration 30,000 per acre, and total sale consideration is ₹3,64,500. And prior to agreement dated 5/5/2003, there was a single agreement between them under Exhibit A1, under which the defendants received 5,000, and after that they also received an amount of ₹45,000 on 6/4/2003, and on the date of agreement dated 5/5/2003. In total, the defendants received 1.5 lakhs, which includes earlier amounts. As per the contention of the plaintiffs and the evidence of BW1, he paid the remaining 2 installments to the defendants within stipulated time. That is 1 lakh on 16/10/2003, and the remaining amount in the month of January 2004. Admittedly, plaintiffs not filed the receipt of the payment made by them in the month of January 2004. As per the contention of the plaintiff lost the original agreement dated 5/5/2003, and receipts while coming to Mahbubnagar from Bhutpur on 28/4/2006 in an RTC bus, and immediately he lodged a complaint with 1000 police Mahbubnagar under A3. As can be seen from Exhibit A3, PW1 categorically mentioned that he lost agreement of sale engrossed on stamp paper number so and so dated 4/4/2003 and also receipts for rupees 45,000, rupees 1,30,000 and 1 lakh. And to that effect, SA of Police Anna Sagar issued A5 certificate stating that the documents were not restored. As can be seen from A3 and A5, the complaint under A3 is lodged in the police Mahbubnagar one-town case, but where
Sir, you're reading entire pleading, sir. I am asking for findings.
Yes.
Page number 19. Para number 19, page number 46. And the finding starts from para 19.
Therefore, on perusal of the entire available on record and the documents that are filed and the citations dated upon them, I am of the opinion that as the plaintiff failed to file the original agreement of sale dated 5/5/2003 before the court, and even they failed to prove the missing of the said agreement of sale 5/5/2003, as the plaintiff one lodged a complaint, 5/5/2003 agreement is not at all in dispute. The written statement may be looked into. They are admitting that we received the amount. And that is the reason why, the trial court ordered to refund that amount, against which a cross appeal is being filed. The cross appeal is being dismissed. The para 22 may be looked into. 48. In the result, suit of plaintiffs for specific performance of agreement of sale against defendants is dismissed. And the suit of plaintiffs is partly decreed for refund of earnest money, directing the defendants to refund 1.5 lakhs, along with interest at the rate of 6% per annum. So the trial court came to a conclusion that the agreement of sale is proved, but not granted the relief of specific performance for execution of sale deed in respect to the social property. Not the question that the agreement of sale is not proved; it is proved. And against this refund of 1.5 lakhs, a cross appeal is being filed. A common judgment is being passed by the appellate court, dismissing my appeal and also appeal of defendants. And no second appeal is being preferred by the defendants against the dismissal of cross appeal.
WS.
This that is not available. But the DW1 evidence may be looked into. DW1 is the defendant number 1. Your lordship will find it at 74. Even and D2 are husband and wife. Not in para 1. Fifth line, last word, being. Fifth line, para 1. Being owners of the said land, once myself and my wife jointly entered into an agreement of sale dated 5/5/2003 with plaintiffs. But the plaintiffs failed to pay sale consideration as specified in the agreement of sale within stipulated time, and a meeting was held in the presence of village elders. And ultimately, the agreement was terminated before the village elders. That is the pleading of the defendants. They failed to prove that the agreement of sale is terminated.
What about 30/3/2023? What is the agreement?
It's a token amount was given, and in a date book, in a notebook, that is there, receipt of 5,000 token amount, and subsequently 45,000 was also being paid on 6/4/2002, and on 5/5/2003, this agreement of sale was executed. So that 5,000 payment, dated 30th March 2003. It is marked as A1B.
The agreement. An agreement is there.
They have, it has been referred as agreement, but only 5,000 token amount is being paid.
Any conditions are there in that ban?
It's only receipt of 5,000. The conditions, is the main agreement is 552,003, and the suit is filed for enforcement of specific performance of this agreement of 552,003.
There is a non-mentioned date. The prayer, page number 56. No date. Your prayer.
May I submit?
Yes, sir.
There's no date. The taken by the defendants that the signatures doesn't belongs to them. And when that is being proved by the plaintiffs, you are persons who have signed it. Therefore, the plaintiffs have discharged the burden, and the burden has shifted on to the defendants number 1 and 2. It is they who has to come forward and say that this is the amount received, not towards the part sale consideration or towards some other transaction or anything other than this agreement of sale. But that is not their case. The burden of proof is an oscillating pendulum. It shifts from one side to the other side. When once the plaintiffs have discharged the preliminary burden which casts on them, then the burden squarely shifts on to the defendants. They have not discharged the.
Show me the documents that pay 5,500. Show me the.
5,500 is not available.
No xerox.
Xerox filed but could not be marked. The plaintiff chief examination will be. No, I don't have the copy. Page 60. But since it is a Xerox copy, that is not been marked. Page 60 is the list of the documents. We have asked the Honorable Court to mark it. So the second document is the copy of agreement of sale dated 5/5/2000. This is not marked. The other documents have been marked.
What are the contents, sir? What are the agreement? What are the conditions? What are the date to?
No, the content, the defendant's stand is that they have executed the agreement of sale, but the payment as stipulated in the agreement of sale is not paid.
Yes, sir.
That is their contention. We have, the exhibit
Which document?
16/10/2003. Exhibit A2 is the payment of an amount of ₹1 lakh.
But the plaintiff failed to pay sale consideration as specified in the agreement of sale within the stipulated time. What is the agreement? Where is the time? I will want to see. Cannot find it. Then that's why the both courts are.
The copy is being filed.
Show me documents then.
That document will not.
Specifically, they accept the 1.5 lakh, but they are not paid within time. That is the play of the defendants before the court below.
As far as the balance consideration, which
So what is the time limit, sir? Show me document.
the document I am not having, I have not filed it.
Produce that.
1 minute. The contention is that the balance sale consideration, whatever on 16/10, 1 lakh was paid. So what the balance amount is paid in the month of January 2004, except the oral evidence. Nothing is
Their WS, they are accepting only 1.5 lakhs.
yes, 1.5 lakh.
Now the court below also returning the.
We have proved the subsequent payment A2. We have proved the subsequent payment A2 received 1 lakh.
Their court only 1.5 lakh is the director to the.
Yes, the condition.
First, I want to see the documents. I want to see the document. What are the
agreement of sale? I don't have a copy of it. In this case, during the pendency of appeal, D1 and D2 created sale dates in.
Sir, first original agreement of sale 3/30/2023. Show me. Or the receipt of 16/10 A1 A2.
A1 is March.
Show me documents. Where is the document? Show me, sir.
The documents are not filed.
Right, sir.
Documents are there.
Right, documents you are basing on marking documents, so we can mark us.
Commissioner report, the commissioner, the FSL is also been, the expert is also been examined, your lordship will find the deposition of the.
Not deposition, sir. I want to see the documents, sir.
May I just clarify, my lords, that agreement of sale dated 5th May on which the appellant is relying on was not even filed with the trial court, my lords. That was one of the basis for the trial court to dismiss the specific suit.
Wait, was
Page
Yes.
90, page 96.
Sir, I want to see documents, sir.
No,
Page
page
96.
96. Page 96 is A2. Page 94.
What
is
page?
A1.
Kotla Narayan Reddy. Narayana. What is it? Surname?
Kotla is the surname.
Then what?
Translation 97 Kotla Narayana, care of Gopanpalli. Vemla Chennaya, son of Balapu. Gopanpalli had executed documents and I have received 1 lakh. And the receipt was made and given to you.
That is 16/10/2023.
Yes, 16/10/2000.
Sir, 83. 16/83.
Not
mention type copy 83. I think 03.
03. And this 94 is dated, it was written in a notebook, 30th March 2003. That also is, I am finding out at page 94.
As per this 38/3/44/2023, 45,000 చెల్లించగలము.
That is also been paid, that is, missed, we have not filed it because they have been misplaced, 6/4/2003, 55,000. And then, on 5/5/2003, the agreement of sale was executed, this is also been missing. Therefore, we could not able to file.
Conditions are 5. Particularly 5/5, sir. What is the plus?
Not here, the suit was not dismissed because we have not paid the subsequent amount. Subsequent amounts, payment of subsequent amounts are being proved. We have examined this tribe of the A1 and A2, and since they have denied the signatures, therefore, both the.
No, sir. Total, the plaintiff failed to prove the payment of entire balance sale consideration, except consideration paid on the state of agreement.
Yes, A1 and A2 are proved. The expert has given his opinion and he was examined, and they have not even cross-examined. Page 88 may be looked into. Page 88 is the deposition. Advocate Commissioner was appointed and he recorded the evidence of FSL expert. This FSL expert is examined as CW1 and the opinion furnished by him is marked as C1.
What is the next appellate court findings?
On similar lines, the appellate court also came to a conclusion. Page 22.
Page 22. Page number?
Page 22, of the running index, the appellate court.
Okay. Para number?
18.
Yes.
In the case on hand, even as per plaintiff's balance sale consideration has to be paid in 2 installments. Plaintiff stated that they paid sale consideration 5,000 on 30th March 2003 45,000 on 6/4/2003, and 1 lakh on 6/10/2003, and rupees 1,50,000 on 5/5/2003. As per plaintiff, total sale consideration agreed was rupees 3,64,500. And they claimed that they paid entire sale consideration, whereas plaintiffs not filed receipt contains to payments made in January 2004. By virtue of the above receipt, plaintiffs only proved payment of rupees 3 lakhs and not proved payment of entire sale consideration. That is it. Not that. Certain receipts have been misplaced. But we have filed a police complaint also. And even otherwise also, only a partial amount is being paid on in the month of January 2004, only 64,500. 3 lakhs is said to have been paid already. Paid on 19. In the case on hand, as per the plaintiff's last installment was due in the month of January 2004 and not placed any material about payment of said installment. Suit was filed in the month of April 2007. By the time 3 years left, will not hear the after the.
Okay, limitation also.
Yes, limitation. I am coming to the last point. Even as per the amendments, they have approached the defendants to execute a sale. They have not come forward. They have also approached the revenue authorities for regularization of this sale. The defendants number 1 and 2 approached before the revenue authorities and they raised an objection. Therefore, the revenue authorities refused. That's how the suit is being filed. So all these facts constitutes cause of action. So just because in January 2004 the last installment could not come, we have not able to prove that last installment payment of last installment in January 2004. Therefore, directly the cause of action arises. Subsequent events are also needs to be looked into. Therefore, the suit is not bad by limitation. On these two grounds, the appeal was dismissed, and they have filed cross appeal. That is also been dismissed. Para 21, para 21, page 23.
Yes, sir.
In the case on hand, defendants admitted agreement of sale dated 5/5/2003 and also admitted receipt of 1.5 lakhs. And they admitted amount paid as advance sale consideration. Defendant number 1 and 2 failed to state and prove that they have right to forfeit the earnest money in case of breach of contract. That's how the cross appeal is also been dismissed. So here the agreement is proved. Subsequent payments also, we have led evidence, we have filed documents. Documents have been proved. Both the courts below failed to take into consideration. Even the expert also gave an opinion. We have examined the scribes of those two documents, A1 and A2. And for a moment, they have denied, they have given a suggestion that the signature doesn't belong to them. PW2 is the scribe to A1, PW2 evidence. The cross examination is at page 69, PW2. And the third last line, in page 69, it is not true to suggest that the first plaintiff got created exhibit A1 through me before that. It is not true to suggest, it is not true to suggest that the defendant number 1 and 2 have not signed in exhibit A1, whether in first page or second page. They have taken a stance that the signatures are forged. And we proved it, no, they are not forged, they are genuine.
Page number 69.
Yes,
Other convention of page.
PW2.
It is true after the first 3 lines and second page left side of exhibit A1, the parties have not signed. First,
This
first line, first two lines.
It is true after the first 3 lines, second page left side of A1, the parties have not signed. In 2003-4, dependents migrated from Gopanpalli to Rachara village. It is not to suggest that the alleged Manscription as shown in it is A1 only. A1 on 30th March 2000 never occurred. It is not to suggest that we have created exhibit A1 after the lapse of agreement dated 5/5/2003. It is not to suggest that defendant number 1 and 2 have not signed in exhibit A1, whether in first page or second page.
Neither in first page.
Neither in first page or second page left side. So this is the specific case of the defendants with regard to A1. They are denying their own signatures. PW4 is because he is a scribe, except giving suggestions, nothing is being elicited in the cross-examination of PW2, who is a scribe to this payment dated 30th March 2003. And the PW4 evidence may be looked into, he is also a scribe to the exhibit A2. And he said he has given his evidence that he also scribed exhibit A2. Cross-examination is at page 73. Fourth line from the bottom, a suggestion was given to the witness. It is not true to such as the signature found in exhibit A2 not belongs to defendants. It is not true to such as that exhibit A2 is dated 16/10/83, but not 16/10/2003. But that is being writing it appears 03, and now they are taking it as an advantage as 83. But even otherwise also, when one signatures are being proved, it is for you. For what purpose in 1983 you have given this receipt?
Yes.
Above para 88. This our own HIGHCOURT above para 88. On the perusal of so and so, section 10 acts retrospectively. The point number 6, the 6th was answered. 2018 amendment is being carried out to specific relief act section 10. The word may is being substituted with the word shall.
Sir, on the above analysis, we are in view that section 10 of the act retrospective in nature and applies to the pending proceedings, and this point according to pending proceedings applies.
Yes, that's
Suit was declared on 2017, not 18. Page number 29, 18 September 2017.
When not retrospectively means we have kept
this code para 88. Retrospective nature and applies to the pending proceedings.
And the word and is being used.
Pending proceedings, sir. No, this is not pending proceedings. Suit was declared on 17.
And means in addition to. And moreover, even today also the suit is being pending because we are in second appeal. Suit is being filed, appeal is being filed, and the second appeal is pending. So the proceedings are pending.
Okay, I'll consider.
That is a substantive question of law. I have stated so. 103 says that when I have discharged my burden, the burden will shift on to the defendants to prove that they have not received this part consideration under exhibit A1 and A2, or they have to prove that these considerations have been received by us but not comes to part sale consideration.
103 Evidence Act and 58 Evidence Act and
58 admitted fact need not be proved. Because agreement of sale, they are admitting it 5/5/2003. Therefore, I need not prove it. They have admitted it.
Where are the conditions? Then show me the conditions. There is no conditions.
Not the agreement of sale is not marked. I am not having a copy of the agreement of sale. But the stand taken by the defendant number 1 and 2, by referring to the depositions, etc., and even the judgment also, they say that we have not received the balance sale consideration as stipulated.
Yes.
As stipulated.
Within time.
Yes, within time. So January 2004, we have paid the whatever the leftover sale consideration, 64,500.
No,
that slip is, we have not filed it. Yes. We have filed the other evidence which have been marked that these documents are being
May I take your lordship to certain observations of the trial court minutes in paragraph 10 of the trial court order?
1 minute. Yes.
Here, D3 and D4, two sale dates have been executed by D1 and D2 pending the proceedings. In the appeal, they are being impeded as parties. They themselves filed the petition in that matter before this honorable court by way of filing CRP. So that's how they are being made as parties to the appeals in the appeal. Now, my lord, these have filed order 39(1) and 2, seeking a direction to defendant number 1 and 2 not to create further documents. Because my lord, already D1 and D2 pending suit, they have sold the plant to D3 and D4. And these D3 and D4 are creating problems to the.
You are representing whom? I am on the possibility.
D1 and D2.
D1 and D2 all the respondents in the appeal.
All respondents.
Okay, all the respondents. Yes, sir.
Lordship may refer to para 11 of the trial court order, that in fact encompasses the actual facts of the case. Because the plea of the plaintiffs, there were two agreement of sale. One dated 6/4 April 2003 and another dated 5th May 2003. This handwriting expert opinion all with respect to the April agreement of sale, which is denied by the defendants. Lordship will find that at para 11 of the order. If you can just read out.
Yes,
as per evidence of PW1, the defendants are the owners and patadas of the suit scheduled land total at measuring 12 acres 6 guntas, and they offer to sell the same at 30,000 per acre, and total sale consideration is rupees 3,64,500. And prior to the agreement dated 5th May 2003, the simple agreement between them under Exhibit A1, under which defendants received 5,000, and after to that, they also received an amount of 45,000 on 6 April 2003, and on the date of agreement dated 5th May 2003. In total, the defendants received 1,50,000, which includes earlier amounts. As per the contention of the plaintiffs and the evidence of PW1, he paid the remaining 2 installments to the defendant within stipulated time, that is rupees 1 lakh on 16/10/2003, and the remaining amount in the month of January 2004. Admittedly, the plaintiffs not filed the receipt of payment made by them in the month of January 2004. As per the contention of the plaintiff number 1 lost the original agreement dated 5th May 2003 and receipts while coming to Mehboob Nagar from Bhutpur on 28 April in an RTC bus, and immediately lodged a complaint with One Town Police Mehboob Nagar under Exhibit A3. As can be seen from Exhibit A3, PW1 categorically mentioned that he lost agreement of sale engrossed on strong paper so-and-so dated 4th April 2003, and also receipts for 45,000, 1,30,000 and rupees 1 lakh. And to that effect, SI of Police Anna Sagar issued Exhibit A by certificate, stating that the documents were not traced out. As can be seen from Exhibit A3 and A5, the complaint under Exhibit A3 is lodged with the police Mehboob Nagar One Town Police Station, but whereas a certificate was issued under Exhibit A5 by the police Anna Sagar. As can be seen from the contents of Exhibit A3, the complaint lodged by PW1 with police that he lost the receipts for 45,000, 1,30,000 and 1 lakh, along with the agreement of sale dated 5th May 2003. But surprisingly, during the course of evidence, he produced a receipt for rupees 1 lakh and marked the same as Exhibit A2.
Okay. Yes, sir.
During the cross-examination, PW1 stated that he traced out Exhibit A to receipt only, but no other documents. The above evidence of PW1 that Exhibit A2 alone traced out and other documents are not traced out creates a doubt. If, as per his contention, he lost all the documents while traveling in a bus, it is for him to explain how he traced out Exhibit A2 receipt alone. If Exhibit A2 is to be taken into consideration, the contention of the plaintiffs regarding the loss of certificates while traveling in an RTC bus falsifies and also the certificate issued by the police. Lordship may also see the next paragraphs. The entire case of the plaintiffs based on the agreement of sale dated 5th May, but admittedly they failed to file the alleged agreement of sale dated 5th May, reporting the same is lost by transit. The plaintiffs claiming that there was an earlier agreement of sale under Exhibit A1 prior to the agreement dated 5th May, but as can be seen from Exhibit A9, legal notice issued by the plaintiffs before filing of the suit, there is no reference of the Exhibit A1 agreement of sale, and also payment of 5,000 on 30th March and 45,000 on 6th April. When these documents, that is Exhibit A1, is in possession of the plaintiffs, they ought to have made reference to the said agreement of sale under Exhibit A1 in Exhibit A9 legal notice, and as admittedly as on the date of issuance of Exhibit A9 legal notice, the agreement of sale dated 5th May 2003 was not in possession of the plaintiffs. And para 13 also. As per the case of the plaintiffs, they have paid the entire sale consideration of rupees 3,64,500 to the defendants by way of 3 installments. That is first installment as on the date of agreement, that is 5th May 2003, and rupees 1 lakh on 16th October 2003, the remaining amount in January 2004. But the plaintiffs failed to file receipt showing the payment of balance of sale consideration in the month of January 2004. Even the Exhibit A2 receipt, which is for rupees 1 lakh dated 16th October 2003, also does not contain the recitals that the said amount was passed towards advance sale consideration. And even as per the case of plaintiff, the said receipt was lost and that Exhibit A3 police report was given to that effect. As the plaintiffs failed to prove as to how they traced out Exhibit A2 alone, when they lost receipts and agreement of sale while traveling in an RTC bus by plaintiff witness 1, and therefore Exhibit A2 receipt creates a doubt regarding payment of balance sale consideration to defendants by the plaintiffs. Not with respect to the handwriting opinion and all manner, which on which the appellant is relying on, that finding is at para 16 minutes. The second line. The evidence of CW1 and Exhibit X1, which is the deposition of CW1, is no way helpful to the case of the plaintiff, as in the present case. The plaintiff's case is not based on Exhibit A1 agreement, and they filed the present case for specific performance of the agreement sale dated 5th May 2003, which is not filed before this court. Therefore, in view of the fact that the suit of the plaintiffs is not based on Exhibit A1, and there is doubt regarding Exhibit A2 receipt in view of the fact that the plaintiffs pleaded the loss of the said document along with agreement dated 5th May 2003, I am of the opinion that the evidence of CW1 is no way helpful to the case of the plaintiffs.
Yes, sir.
Not in appeal also, man, same finding, which were read out to your lordship, para 18 and 19.
Yes, sir, consider. Post for clear both sides.
As far as A1 is concerned, it is only shows that a total amount is being paid, 5,000. Okay. The agreement was reduced into writing on 5/5/2003. That is not.
Sir, where is the legal notice, sir? I want to see the legal notice.
Copy of legal notice notes 103 to 104. 103.
Okay, there is no mention about 3/3 of 2003. That is 3,003 and October also. Only mention only 5,503. This legal notice. Only
legal notice also.
legal notice only for date of 5,503 only.
Yes. But even otherwise also, stand taken is that earlier also 50,000 is being paid prior to the execution. Agreement of sale. Now in the legal notice that is not reflecting. Point is not here the agreement of sale is being not proved. And once an agreement of sale is being proved, not even not court comes to a conclusion that still I owe some amount, not that amount not the plaintiff will pay me. Here the entire only refund is being ordered 1.5 lakhs.
Yes, sir, consider. Here both sides both orders after 3 weeks.
Final judgment.
Yes, I'm thinking.
And word and is used. And is means in addition. Because even the Hindu Succession Act is also been referred in the judgment.
Yes, sir.
Section 6 amendment made. Whether it acts.
I will consider.
Item 93, agenda item number 94. P. Bharat Kumar G. Masudan Reddy.
Yes, sir.
Petition to have many of all in the clear petition and many also lot to pay.
How much delay?
9 days and annual bond.
Huh? I will consider and pass on. Allow the, yes. 94 days delay.
Yes, 94.
Here call for petition respondent. 11. 94 days allowed.
Petition the delay petition also that they done with the smooth and update. The filing of the delay is shifted the burden to the arbitrators. You know everything last pursue the matter for the appellate court also. Delay petition is not approved.
I am uneducated and my crossing appeal did not inform. We don't know.
I think it's lost.
Yes. Yes. Control. Post for admission after 2 weeks, sir. For 2 weeks.
Item number 95, Jaypal Reddy, Kasi Reddy, Sharad Sanghi.
Yes, ma'am. Ready? Today? I am saying. Yes, you are also not ready. And look at both sides post after 4 weeks. Demand recommend till then. 4 weeks.
Item number 96, J. Prabhakar, Srinivasa Rao.
We have it after 1 week, So the appeal arises out of an employee compensation. One minute, as by the commissioner. Recently, a delay was confirmed and has been numbered now.
2015 matter.
Yes, but whether the causes available and let.
Yes, sir. And look at both sides post after 2 weeks.
Item number 97, yes, Srinivasa, E. Rohit.
This is a new petition.
Okay. After those sides, it's technical requirements post after 4 weeks. Yes, sir. The requirements post after 4 weeks.
Item number 98 and 99, C.
Yes,
Rafi Reddy, MBBS, Nursing Family.
Conference fund seeks time post after 4 weeks. This is my election till then. One of they mentioned, madam.
Every month. 4 months. Just for 2 weeks only, but issue is discussed.
For 2 weeks, you are election till then. One of the tentative they mentioned, but since I was there.
Item number 100, B 100 and 101. B Sudhakar Reddy and Major and GT services too. Yes, Surendra Reddy.
Yes, sir. You are not ready? Again, you are given an OC. I think you are a second advocate. This matter. Also, the people respond. Respond, you are a file review petitioner.
Yes.
Counsel. You are sir? Okay, AGP. Counsel. Review petitioner. Even one. OC. 6 times. Post after 4 weeks.
Item number 102 to 105. Yes, Teja.
Yes, sir. What is this matter?
Before the vacation also, two matters where our right to.
Okay, wrongly permitted, wrongly filed letter for withdrawal. This matter. Yes.
So you are filing in some other case that letter was.
Yes, yes. Yes, but you are representing whom? Yes, 102 to 105 same connected matters.
Correct.
Yes, sir.
They are pressing for the matters in the right to taking adjournment. Right to cross-examine the husband was forfeited on the ground that our lawyer was absent on a particular day, that is 5th December 2022. But the lawyer is filed a affidavit and he said that he was in Delhi. My lord, attending.
Okay, wife filed petition for such days.
Yes, my lord, that's correct. So, my lord, the lawyer, my lord, was in Delhi attending a National Consumer Dispute Secrecy Commission case. He filed cause list and air ticket also. But on some cause it could have been allowed. Now, my lord, I don't get a chance to cross-examine the husband. It's a very, very harsh measure by the lower courts on cost. It may be allowed or only one opportunity. I'm not asking for more. One opportunity may be given. I will go and cross-examine the husband on the next day. Heavy cost may be imposed. It's a local witness only. Lord, if I am not allowed to cross-examine, my lord, that husband is married second time also. All these facts I will not be able to elicit in the trial.
To 13 No.32. The recall petition filed, reopen and recall petition was filed, and now the petition is they were allowed after imposing several conditions. Orders period one was partly cross-examined on 27/6, 25, 27/7, 28/2, and 28/9. Pertaining to the road pendency of 2017, so directed the petitioner to complete the target at 11:10. On that day, also the petitioners were sought adjournment and this court and the given the result, the cross-examination of the recorded name.
Was 512.
28/12 are conditioned to a complete cross-examination when
That is
present
no,
without
that's past. All that was questioned by the trial court only. Now we are now on 512.
5/12. On that day, there was no representation of the petitioner respondent when the matter was called on bench. The present at the time of call up when the matter was called on adjournment petition was placed before the bench by.
No, that is the adjournment petition. Our right was forfeited on 512. Lord, I am asking only one opportunity. Only one opportunity.
Already cross-examined partly on 5 case. 1, 2, 3, 4, 5.
No, you had a case. Only one opportunity. Only one opportunity. Just after cross-examination, not more.
No, what I'm saying. Already 4 times, 5 times. On 27/6, 57, 77,
I
27.
understand, my lord. We could have conducted the trial in a better manner. I understand what you are. All in our question.
Only one option.
Just what are the other, how many CRPs?
44.
Four. For petitions for? One is?
Both is filed with husband. One is for divorce, one is for custody of child. So the two CRPs are, one is for reopening.
Is that the common orders passed in OP number 497?
Yes.
IA number 1082 and 1083. Okay. Recall and
Yes, ma'am.
reopen update.
Reopen.
PWR on the examination.
Yes.
Improvement is same.
Same. Common trial is going on.
Yes.
They are taking adjournment here and they are pressing now. We are going to face.
When was the next date of hearing, sir? When was the next date of hearing? Next date of hearing.
Next date of hearing, I think next week, my lord, they put there. Now, my lord, we are in a very precarious condition and we may even face the ex parte decree also there. Because the court is saying you have not got any stay order from the High Court and I shall pronounce judgment. We'll be in a very bad position. If they want to take adjournment, my lord, most welcome, my lord. At least please protect our interests for 2 weeks more. 2 weeks. Then let Mr. Gaud come, we can argue the matter, my lord. This matter came up before vacation also, your lordship recalls.
Yes, sir.
Just short stay, your lordship. Mr. Gaud come.
On 17th, and normal the petitioner, sir. 17th. Normal for petitioners. On 5th, you are paid. I don't list on 16th, but listed on 17th, but normal for petitioners.
Maybe it must be. It came before Dasra vacation that I remember.
They filed counter. Before.
They filed counter. After counter also the matter came passed.
No, sir.
Or they filed in the section. They asked me. So you are filing for some other case, you are filing.
Yes, sir. Then I'll post out for 1 week, sir.
That is something bad will happen in 1 week. No. I'm requesting very humbly. What they are taking adjustments here, but in the lower court.
Actually, what is the exact? Tell me what is the eco status? What is the decade of hearing? Verify, madam, the eco.
Our right to cross-examine is forbidden. Post it for judgment or for arguments or something like that. So therefore, my lord, just 1 week I am asking.
Okay. One correspondent seeks time. Post after 2 weeks.
Yes.
Till then.
Yes.
Forbidden that. Not to push it further. Yes. Absolute numbers also. Should I little normal time. Yes. Till then, sir. Till then, sir.
Item 106, adjourn. Item number 107, S.V. Ramana C. Harshpreet.
Madam, morning post is around the other matters. Item 106. Okay, council will has 6 and post after 4 weeks.
Item 108, adjourn. Item number 109, N. Ashok Kumar, N. Naveen Kumar.
Next question.
Extension coming up.
Finally, yes, sir. Asking for extension of interim orders. Time is 4:25. First step.
Well, paper book is also filed in this court paper book. In fact, my lord, the matter of 2021, in fact, there is no great urgency. There are some very old matters.
Yes, sir. You are interim orders, sir. That's why I'm saying like that.
No, your lord. With your lordship's permission, I appear for the respondents. In fact, your lordships will see it's only a limited stay because I was not available on one day. Lordships are not heard on the IA. Lordships may hear it. We are ready for the arguments.
I'd like to bring out.
Time is now 4:26.
Lordship may have it tomorrow, Your Lordship. No hurry and no issues.
Not tomorrow, sir. For 2 weeks.
Lordship may have it after 1 week, Your Lordship. Urgency because the final hearing final proceedings have been stayed. Final decree proceedings, Your Lordship. May have it next week, Your Lordship.
Huh? Wait, he is submitting something. Where are you interrupting? First of time, post after 2 weeks. Till then. It's up 2 weeks of age. First of time.
Item 111, interest item number 112, Jaganmohan Perumal.
Because infrastructure, morning mentioned that. Come. Any other instruction? Huh? Yes, already they are submitted. Post after 4 weeks.
Item number 113, yes, Chandrayan, please Srinivas.
The claimant certificate, IA number is discussing application.
Already ordered, sir. Long back. And 7 8 I have ordered.
Yes, but please proceed for hearing.
You gonna stop this?
Question for well hearing.
Sir, first you have to verify call this, sir. Already they listed him only for hearing. Okay. Post this matter for final hearing. After 8 weeks, meantime, receive call for the record for the court below. Okay, sir. What is your matter? Right now. Two minutes.
Item number 114, please, Sarah Pumaram.
Millard, please, Lordship.
Yes, sir.
Millard, this is an appeal, Millard, in a suit between two companies. Millard, the appellant before your Lordship is an Oman-based chemical company. Millard, it has put an order for supply of huge chemicals to a Hyderabad-based chemical company. Millard, there was some agreement, Millard, and ultimately, Millard, the Hyderabad-based company, which is the plaintiff, Millard, it dispatched the consignment. Millard, on voyage, Millard, the ship was burnt along with all the Millard chemicals, the goods that contained. But the question that arose is who has to bear the risk of it? Millard, the question is whether the sale was complete the moment it was dispatched, or the sale would be complete when it reaches the destination port. Because on voyage, Millard, the ship was burnt. And on that, Millard, they filed a suit. The Hyderabad-based company, they filed the suit for the recovery of that amount.
Yes.
Millard, that was hotly contested. Millard, now ultimately, Millard, the learned judge found, Millard held that the moment the goods was unshipped, but the sale was complete, and only the defendant has to pay the plaintiff. That was the decision that was rendered, Millard. I guess that meant the present appeal was filed. But if I'm correct, Millard, about 20 years have gone after filing of the appeal. To my knowledge, Millard, there was no stay. Millard, I don't think, Millard, for all these 20 years, Millard, they would keep quiet. Millard, what I feel is that, Millard, apart from that, now I'm unable to trace my client. Because at that time, Millard, somebody was there between me and the Oman company. Now that man is no more there. I could not find him. Millard, I'm trying to, Millard, establish some communication with that Oman-based company. Leaving about that, Millard, I have got my own doubts. Because for the last 20 years, Millard, they did not file any EP.
Yes, sir.
There was no stay. Millard, I feel, Millard, the decree itself became time-barred.
Yes, sir.
And in such a case, if I argue the case, Millard, and if ultimately, Millard, a decree was passed, Millard, dismissing this one, Millard, the theory of Millard, merger of decrees, Millard, would come into operation, then I will be doing some injustice to my client. Yes, so, Millard, what I feel, Millard, you'll actually have it on 22nd, Millard. Meanwhile, I try to find out, Milad, if I don't press for this appeal, Milad, that merger of decree theory would not come into operation. That's what I have been thinking. And meanwhile, Milad,
I'm possibly I'll dismiss the appeal also on that day. Okay.
Milad, 22nd, Milad. 22nd. Yes, Milad. Verbalize.
Name is Guneshwara is there, sir?
Yes.
Yes.
On that day, I would just request for the post. Second.
Most of the plaintiff, therefore the plaintiff has to contest the appeal also. Because
Somehow they don't want to prosecute the appeal, sir. That's the problem, sir. We don't know. They'll hear this, sir. Forget all this.